Okay, good morning, everyone, and thank you for joining us for the Medical Board of California quarterly board meeting. While this meeting is being conducted with all participating board members and staff at the Sacramento meeting location, this meeting is being streamed interactively using WebEx to allow for remote public comment in the same manner as recent meetings. Public comments will be heard for each agenda item for individuals wishing to do so in person and remotely. To be ready for remote public comment, we ask that you please ensure your comments can be heard clearly by connecting to the audio of this meeting through the proper method. If you're having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone with the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the instructions on how to connect on the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, President Lawson. You may now start the meeting.
Morning, everyone, and welcome to day 2 of the quarterly meetings of the Medical Board of California. I'd again like to just ask all the board members and those here in the room with us in Sacramento to just turn any devices that you have to silent so there are no interruptions. For those of you in the public and watching us online, you may notice that there are board members accessing their laptops or other devices during the meeting. They're using their devices to access board meeting materials that are in electronic format. If you're a member of the media and require assistance or information, please see the board's public information officer, Carlos Villatoro, back here on my right. We will have a designated time on the agenda for public comment, and we will ask for public comment on each item on the agenda. This is an official business meeting of the Medical Board of California, and as such, disruptions will not be tolerated. Government Code Section 11126.5 allows the board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by removing or muting the disruptive people. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, just please do raise your hand or come forward and you will be recognized. I'd like to request that all speakers here in the room with us in Sacramento please complete a speaker slip so I can call you by name at the appropriate time and the record of the meeting can be full and complete. However, this is voluntary. Please give the speaker slips to Ms. Toof, and Ms. Toof, if you could identify yourself. Thank you. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those as well who wish to make a last-minute comment. As Sean mentioned, this meeting is also being streamed via WebEx. Individuals attending the meeting remotely via WebEx will also have an opportunity to provide public comment and will be assisted by the host who will be facilitating the WebEx meeting. During each agenda item, the host moderating this WebEx event will activate the hand raising and the Q&A features of WebEx and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes on the Q&A window. The host will then call on individuals who indicated they wish to make public comments by the name provided by the individual, which may be a pseudonym. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment. The host will audibly announce when 30 seconds remain to conclude the public comment, and after the 3 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. And please do see page 4 of the agenda for WebEx instructions on how to connect from the link on the agenda and for additional helpful instructions. During agenda item 12, public comments on items not on the agenda, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for the comment period, and after 20 minutes, no further comments will be accepted. Each person, again, will be limited to a maximum of 3 minutes per agenda item, but this time period may be reduced depending on the number of people who wish to speak. The board's IT staff will assist me with receiving the public comments via WebEx during this meeting. And I would like to remind all speakers to please stay on topic and keep your comments to the allotted time. Today's meeting will be run in accordance with the Open Meeting Act as required by law, and we do plan to end today's meeting by approximately 2 p.m. I would like to officially call this meeting of the Medical Board of California to order at 9:10 a.m. Ms. Moriarty, please call the roll.
Mr. Brooks?
Here.
Dr. Gonadev?
Here.
Dr. Hawkins?
Here.
Dr. Hilzer?
Here.
Ms. Jiang? Ms. Lubiano?
Here.
Dr. Mahmood? Mr. Rue?
Present.
Dr. Thorpe?
Here.
Dr. Tsai?
Here.
Mr. Watkins?
Present.
Dr. Yip? Ms. Lawson?
Here. Thank you. A quorum is present. I would like to remind the members again that we will be taking a roll call vote on all action items, and we have quite a few action items today. Moving on to agenda item 12, public comments on items not on the agenda. Just a reminder before I ask for public comments that I would ask individuals making comments to not discuss pending complaints, pending licensing applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they could provide information to members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and could lead to a board decision being challenged in Superior Court. The board can receive comments during this agenda item regarding the board's processes in general, but it cannot receive comments on specific case circumstances where a decision is still pending. In addition, the board requests the public to address the board as a whole and not individual members or our staff. Please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between board members and the public. The only action board members can take is to listen to comments and decide whether they'd like a future agenda item on the topic. No other action can be taken on the item at this meeting. Though this may seem at times like the board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed and to avoid compromising the speaker's goals or the board's mission. If you want to comment on this agenda, on an agenda item, please do wait until we get to that agenda item. Comments at this time are only for items that are not on our agenda. Please do limit your comments to 3 minutes or less. Are there any comments from speakers in the hearing room today? All right, seeing none. Sean, are there any public comments on WebEx this morning?
Yes, for anyone wishing to make a public comment, please use the hand-raising feature in WebEx or type something in the Q&A box. I see a call-in user as well. If you're called in only on a phone, you can use *3 to raise your hand in order to make a public comment. First up here, we have Kristen Ogden. Kristen, you should be getting that request.
Can you hear me?
We can. Please go ahead.
Okay, thank you. This is Kristen Ogden. Thank you for the opportunity to comment. I want to make a few comments about the implementation and requirements for the pending update of the California guideline for prescribing opioids. The information you shared with us yesterday was very positive and very promising, but as I've thought it over, I am brought back to considering that, in one way of speaking, the devil is in the details, so to speak. It will be necessary to encourage doctors to come back to treating pain with some assurance that they will be protected from overzealous scrutiny that can feel like harassment to the doctors. I know a number who have just given up because it was too much trouble to the harm of patients. You must protect the pharmacists who dispense the medications. Pharmacists have been disciplined in some cases. You must push back, be prepared to question activities by the federal government that may interfere with carrying out what you have the right to do as the state. Push back against the DEA overreach in California, push back against unnecessarily restrictive policies that limit access to care and access to medications. Ensure that your investigators and expert reviewers, should they be asked to look at someone who has been practicing intractable pain care, be sure that they're truly qualified and that they know what they should be looking at and what they shouldn't delve into in depth. It will be a huge job to work to overcome, to educate people about the stigma. That's tremendous. Your interested parties meeting, I wasn't clear whether that is actually going to be a public meeting or by invitation only. If it's by invitation only, Families for Intractable Pain Relief would very much like to be invited, and we will certainly be trying to follow your actions and the developments in this regard throughout. To my knowledge, FIPR, the Families for Intractable Pain Relief, is the only advocacy group that specifically advocates for intractable pain patients who may require high doses of opioids. And I think that we have a perspective that is unique, and we would like to share it to the maximum extent that we can. I would suggest that you might consider whether you might actually invite the true expert doctors to come back.
30 seconds remaining.
People are not going to come back unless they have assurances that their services are wanted and will be valued and that they will be protected. Also consider inviting intractable pain patient advocates to have an advisory role of some kind as you work through the completion and implementation. I think if the right steps are taken, what you have come up with, if it is as you describe it, has the potential to be a huge help to many people who have been suffering. Thank you for the opportunity to comment.
Thank you for your public comment.
Sean, I just wanted to provide a clarification. To the extent it wasn't clear yesterday during our meeting, Ms. Ogden, the upcoming interested parties meeting will be open to the public, and we'll make sure that you receive an invitation as well, but that is a public meeting. Thanks, Sean. Next public comment, please.
Next up, we have Dr. Hannah Ree. You should be receiving that request on your end here.
Yes, hello, can you hear me?
We can. Please go ahead.
Thank you. So, medical board members, fellow advocates, and other attendees. So what we're facing really is the convergence of different interests with really only one just and reasonable solution. As we all know, it's not reasonable to charge physicians, $10,000, $20,000 a year to renew their medical license just to be able to hire staff, decrease turnover time, and that kind of thing. So it's impossible really to respond to 10,000 complaints a year. Then on the other hand, we have the advocates such as myself who have no justice and no resolution in regards to their to the death of their loved ones. Then we also have physicians such as myself who have been fraudulently retaliated against for being a whistleblower despite not a single patient complaint to the medical board. Then finally, what we're coming to realize is that in fact, what we have is a cult of corrupt California attorneys who seek to increase their power and wealth by making no effort to comfort the victims of crimes, always find physicians guilty at the time of hearing, protect their own cult member physicians, and diagnose patients in replacement of physicians. The cult of California attorneys is leading patients to require the approval of attorneys to acquire medical care. The only solution truly to bring about justice is mediation. Attorneys are not trained nor required to be kind, thoughtful, considerate to patients and their loved ones. Their job is to robotically defend the statutes and laws to their own end, of which they can be replaced by AI technology eventually. Ms. Castro and Mr. Prosivka are at different ends of the spectrum. Castro seeks to revoke licenses and Prosivka seeks to heal the doctor-patient relationship. Therefore, Castro seeks destruction and Prosivka seeks justice. Our legislation, for which we are going to author and
30 seconds
present,
remaining.
will downsize the cult's role and establish the healing of mediation. Attorneys do not know how to heal. Physicians do. Thank you.
Thank you for your public comment. Up next, we have Eric Andrus. Eric, you should be receiving that request on your end. We can. Please go ahead.
So no one has ever been able to explain why it is that the board can read or watch news stories about doctors every day of the year, even if they have pending accusations with the board. but the public isn't supposed to talk about them at the board meetings. You can't control what the board sees or hears in their free time, so it's ludicrous that you attempt to stifle our First Amendment right to free speech at these meetings. I've asked Carrie Webb, staff attorney, about this numerous times, and she's refused to reply. Guess she's tired of being proved wrong. And just want to call attention again to the interested parties meetings that the public was told would happen 4 times a year and now aren't happening at all. This happened after Bill tried to railroad the agenda into only things he felt comfortable with the public talking about, but it backfired big time on him. Ever since then, there have been no interested parties meetings. Again, this is not the way to show that you want to hear from us. The state has a huge budget surplus right now. How many board members have been out petitioning all the legislators asking for more money so the medical board can truly do its job? Or do you all just sit and do the bare minimum it takes to fulfill your positions? I don't recall hearing a report of anyone saying, and I'm not saying that you didn't, but I haven't heard a report of anyone saying that they've been out contacting their legislators for any matter to improve this board or make sure it is financially viable. And I know that Christina does talk to legislators. I'm talking about the board in general. How many of you are willing to look legislators in the eye and say, we keep telling you that we need to protect consumers and you keep cutting it down and taking it away? Are any of you brave enough to get out there and actually do that? Or are you just going to sit there on your seats and show up, quarterly to these meetings and pretend to participate? Yesterday, I brought up how the app still doesn't work. I have all my devices maxed out with the maximum number of doctors I can include. Here's how it doesn't work. If you don't keep the app open at all times, you don't get notifications. Then when you go back in and finally do open it, they flood in. Most of the time when you click on the notifications, the description of why you're getting the notification is cut off. Then when you click to go into the doctor's profile, it's impossible to see what information has changed. I assume that any little change to the profile triggers a notification. But if you can't tell what the change is, they just become an annoyance. I guess then you expect people to read your disciplinary documents all in legalese on these tiny cell phones. It's really just a farce. It's easier to use a web browser on your phone and go into Breeze that way, especially since it's identical information. The only difference is not being able to store profile links for easy access. I also mentioned yesterday that Breeze is still not ADA compliant. Many of the fonts are too small to read. This is something that both Julie D'Angelo-Felmeth and I brought up probably 3 years ago or more after the big web design change, and it's still never been fixed. So it's a joke when Sean talks about ADA compliance. Okay, I had a little bit more. I hope you all saw my tweets last night, especially that Dr. Dev Gananadev thinks the COVID pandemic is nearly over. Amazing, isn't it? It's spiking in LA, Dev. Thanks.
Thank you for your public comment. Next up, we have Ann Fuquay. Ann, you should be getting that prompt on your end.
Can you hear me?
Go ahead, Ann. We can.
Okay, great. My name is Ann Fuquay. I'm with Families for Tractable Pain Relief and National Pain Advocacy Center. As Kristen Ogden said, we both last night, I think, started to think, about the issues regarding, I guess calling it just getting physicians that being willing to practice pain management again. And that, I think that will be an issue. And then beyond that, I just, as Kristen said, we'll definitely look forward to participating in the interested parties meeting. Thanks so much. Bye-bye.
Thank you for your public comment. Next up, we have Susan Lauren. Let me get your line open here. Should be receiving that request.
Hi, good morning. Can you hear me?
We can. Please go ahead.
Thank you. Ms. Castro made it sound like medical board experts are saints. Some exploit their expert status to sell themselves on TV and in court and mislead and harm customers. As for her statistics, many people harmed by doctors don't file due to threats and gags and because this board lacks integrity and credibility. Prudent means acting with or showing thought for the future. Saul Berger was not prudent. The paperwork doesn't match what he did. As one surgeon said, the assault exceeds all semblances of sanity. Mr. Prasiska said the board does not go searching for complaints. I came to you with my complaint, but medical board and AG and your expert Terry Dubrow lied and protected Saul Berger. We regularly see tragic, preventable harm done by plastic surgeons doing scams, unnecessary procedures, and assaults. I would like to know what Mr. Krasivka is doing to focus on prevention and science. Why has nothing been done yet? Why do you ignore surgical assault? Why does the medical board contract with a so-called expert sanctioned until 2028 by the Military Health Agency? The doctor who referred Berger refused to put me in a gown, do a hands-on exam, or coordinate appropriate care. Rather than attend to problems Berger caused, she put me on medication inappropriate for me that caused me serious and dangerous reactions. I asked her to stop the medication and send me for MRIs or to a doctor who would physically examine me, but she refused, so I went to Cedars-Sinai ER to report and get help for surgical assault, mistreatment, and misdiagnosis. Cedars staff told me, an assault victim, I was not a priority. They had me wait on my feet all day, which I was unable to do, so I had to cry out for help. They refused to do the appropriate exam, mistreated and misdiagnosed me, which caused continued medical harm. Still, without an appropriate exam, another doctor put me on 11 unneeded overlapping medications. For $250 an hour over 3 months, she mistreated mutilation and hazardous drug effects as pathology. Her obsessive polypharma left me unable to eat or function and nearly killed me. She gave me drugs in used, dirty bottles. Only by getting off those misprescribed drugs was I able to be myself again, but harm has been done. I'm concerned that doctors refuse to listen and often spin injuries as psychological problems. Doctors do this to my massage clients frequently, and it's commonly done after malpractice. This creates a false record and serious problems. The medical field needs a reset on psychological diagnoses. I recommend David Rosenheim's paper on being sane. I'm almost done. In Insane Places and the site Mad in America. Using one-sided medical records is like asking rapists for their accounts of their crimes. Make it standard for consumers to contribute to and correct their records. And I support the pain patients. They did a great job. Thank you. Thank you.
Thank you for your public comment. Up next, we have Virginia. You should be getting that prompt on your side now.
Just reading over the transcripts and the whole essence of what I've been saying, not the whole, but much of what I'm saying is not transcribed properly. It leaves out the essence of it, which makes it pointless. And some of it I view as not helpful. So if you can't properly document the essence of what I say, don't document it at all. It's just like what the doctors did to me. And it's very frustrating. I agree with Susan Lauren about medications. I was put on over 15 medications that have a neuropsych effect for pain that was 100% treatable if I had the right doctor. And doctors don't understand the side effects of those medications, and it just made the matter worse. And again, you need a patient expert on the board to help guide your journey. You need to adopt trauma-informed protocols and trauma-informed education units. And you need to focus on prevention, along with investigating the impact of the CMA on patient safety, which is significant. And lastly, thank you for what you're doing with pain. It was really nice to hear what you're doing and the engagement of the members regarding pain. And I hope that you include trauma-informed care with pain and also improve your standards, because pain such as female pain does not have dissemination of the proper information, and it takes women many, many years to find the proper diagnosis. Thank you.
Thank you for your public comment. Up next here we have Christina Hildebrand. Give me a second to send you that request. You should be receiving it on your end now.
Hi, Christina Hildebrand. Can you hear me?
We can. Please go ahead.
Great. Thank you. Christina Hildebrand from A Voice for Choice Advocacy. We educate and advocate for informed choice and transparency of what goes into your body, including pharmaceuticals and cosmetics and things like that. I wanted to speak to SB 920, which was a bill that was introduced by Senator Hurtado and didn't move forward this year, thankfully. it was interesting because when I first read about it in the LA Times, I was overjoyed to hear that patients were going to get a place in the hearings during the time that when the doctors were giving their side of the story and their lawyers, that patients would be given time to speak about their experience during those hearings. Unfortunately, the bill did not do that at all, and which is why we were glad that the bill didn't move forward. But I would really like the medical board to think about that. You know, a patient files a complaint, or a complaint is filed against their doctor on their behalf by somebody else, by another doctor, by a nurse, saying that the other doctor didn't do a good enough job. But the patient never actually gets a time where they can have their say. They can't be put, before the quote unquote court to give their say. And I really think if the medical board really wants to do something to change and to ensure that patients feel that they're being heard, that allowing the patients to have a voice if they want to, they don't have to, but allowing them to have a voice at those hearings so that they can describe to the, again, quote unquote court and to the judge what happened to them or what didn't happen to them and why that doctor shouldn't be disciplined, which in many of the vaccine medical exemption cases is the case. But I'm also hearing it from the other side, many, many times over here on these calls. I think the medical board also needs to look at why doctors are leaving California. These laws are being passed, like these misinformation and disinformation laws, which in their right place are fine, but they're political. The reason why there's those laws coming forward is completely political. It's completely over COVID. I hear other advocates speaking about misinformation and disinformation on other procedures. And by all means, there should be something in place, and there already is. The medical board has the ability to
30 seconds remaining.
Discipline over misinformation and disinformation, but you've got to make things less political. The medical board right now, what I'm hearing is completely politicized. If it gets in the news, if it gets in the papers, if it's a active, something that needs to be heard about because the news or the legislature is doing it, then you act on it. But when it isn't, you don't act on it. And I really, really ask the medical board to stop doing things that are political. Thank you.
Thank you for your public comment. And next up here, we have Michelle Montserrat Ramos. Michelle, give me a second to send you that request. You should be receiving that request shortly. We can hear you, Michelle. Go ahead. Oh, I thought I heard you there for a second. Sorry, Michelle, go ahead.
Oh, good morning, board members. I would like to welcome new board member Dr. Tsai to the board. My name is Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We are a nonprofit that focuses on consumer and public interests. My focus is on healthcare. I have a large team of advocate families that I bring to the meetings with me. They effectively use their tragic stories to advocate for policy and legislative changes. Personally, I became a state national advocate many years ago, following the death of my husband-to-be after he died tragically at the hands of a substance abusing doctor. I worked on a number of policy and legislative changes here that have helped bring some consumer protection, but we have so much more that needs to be done. We hope that you will keep the public interest in mind when you make decisions as you do physicians' interests. Thank you.
Thank you for your public comment. This time I don't see any additional requests in queue.
Thanks, John, and thanks to all the public commenters this morning. We're now going to move on to agenda item 13, which is an update from the Board of Registered Nursing on AB 90, and I think Ms. Melby is with us this morning.
Yes, thank you. I am with you today, but I do have some video issues, so I'm not able to get my camera to work. It just shows the BRN background. So that's me today. I apologize, but I do want to give an update. We did have our board meeting yesterday and the day before where the regulatory package for AB 890 did go through. There were some updates. It did go through our Nurse Practitioner Advisory Committee, but it is as close to a final format that it's the most final format we've got so far. We still are pending a couple items. We do not have the OPES examination review completed. I was told by Tracy Montez, who is kind of spearheading that they will be meeting with physicians to get their feedback in June. And so we're hoping that it will wrap up shortly after that. They do have in the statutory requirements until January of 2023 to provide us that feedback to see if an additional examination is needed for the nurse practitioner to complete the transition to practice. So they're not delayed and we're not behind. We just don't have that information yet. And so when that information comes in, if an examination is needed, we will have to amend the regulations at that point to add that. We have moved forward right now just to get the process started, to get the review completed and to get that out without an examination to date. The next part that we're waiting to wrap up is when AB 890 was written, they gave the BRN fee authority for the 104 NP. And the 104 NP, what that is the nurse practitioner that can practice independently under their national certification in their private practice. So that can't happen for about 3 more years anyways. So again, we're not delayed, which is good, because they have to become a 103 NP before they become a 104 NP. And one of the requirements to become a 104 NP is 3 years of practicing as a 103. So we do still have some time with that. The other thing that we did reach out to Wood office is for to be included in AB 852, which is a cleanup bill. It's also a pharmacy bill now that talks about electronic submission, but there is some cleanup language in there for nurse practitioners to get fee authority for the 103 certification as well. And the 103 NP, just for clarification on here, is the nurse practitioner who has worked under standardized procedures underneath a physician for 3 years, has completed that, and maybe if OPES requires an examination, complete an examination, then they can work without standardized procedures, without an overseeing physician, but they will be part of a group setting with other healthcare providers. And so they are not yet independent. At that point, they do have some collaboration. And so just to kind of explain that process there, we're waiting to see if we can get some fee authority on that, and then we will go and do fees. But as it stands right now, it was approved by our board on Wednesday to move through the regulatory process. So we will finalize the initial statement of reasoning, the final statement of reasonings, and the executive summary. We will get that turned into the DCA for review, as well as getting that turned in for agency's review and then to the Office of Administrative Law. We did plan to have all of this completed by January so that it can be implemented. So we did do a lot of stakeholder meetings and reached out to get feedback. And I think we're at a pretty final format here, and we should not receive, my hope is that we don't receive a lot of comments that have to go back to maybe like another 45-day period. So we're hoping to have this done and through and implemented by January. I can provide you guys a link on our website on rn.ca.gov. If you go into our meeting materials from yesterday, then from this last 2 days, you'll see the regulatory language as part of that. I don't know if that was pulled into your meeting as well so that you guys have that language. But it is on our website so that you guys are able to review it and have any questions. And at that point, I'm here if you have questions. I'll stay through public comment and see if any additional questions pop up. But other than that, my report is complete.
Thank you, Ms. Melby. Are there any questions or comments from any of the members? All right, seeing none, we'll go to public comment. Any comments from the public present in the hearing room? All right, let's go to the WebEx, Sean, please.
Yes, if anyone would like to make a public comment, please use the hand raising feature or type something in the Q&A window. If you're on a phone-only connection, you can press *3 to raise your hand. First up, we have Dr. Hannery.
Yes, thank you. So, Hannah Rhee, Black Patients Matter. Um, we would just like to say that we're concerned that there is a lack of diversity in the nursing board's leadership. And so it would be something that would benefit the state of California to have that diversity in its leadership at the nursing board. Thank you.
Thank you for your public comment. This time, there are no additional requests in queue.
All right, thank you, Sean. Are there any other comments from members? All right, seeing none, we'll move on to agenda item 14, discussion and action, possible action on legislation. Mr. Bone, I think this is you.
Am I on? Okay, great. Good morning, Madam President and members. I'll get to my notes. Nice to see you all today. This is item 14A regarding legislation pending before the California State Legislature. Since the board's February meeting, legislature has been quite busy with committee hearings, considering bills introduced this year and those that were left over from last year. The rest of May and June of this year will continue to be extremely busy before the legislature takes their summer recess during the month of July. And then they'll come back in August and they'll sprint to wrap up their work for this two-year session at the end of that month. Turning to the bills on today's agenda and looking at the tracker list, there are bills shaded in blue. Those are bills that the board already has a position upon and have not been amended since the prior meeting. So we do not suggest discussing those today. One exception is Senate Bill 1441, which is a placeholder bill known as a spot bill that deals with non-conventional medical treatments. The analysis in your packet is there, but I expect the bill to be changed substantially later on in the year, and therefore suggest the board does not need to take a position on it at this time. Further, I wish to share that two bills shaded in green on our agenda, Assembly Bill 2055 and Senate Bill 1365, were held by the legislature yesterday and are not moving forward this year. Therefore, no discussion is required on those two bills. So unless there's any questions, Madam President, I suggest we proceed to AB 852.
That'd be great. Thanks, Aaron.
There's two components to AB 852. You heard it mentioned very briefly by Ms. Melby in the prior meeting, prior agenda item. This component makes a number of technical changes and cross-references to the nurse practitioner laws that did not get included in Assembly Bill 890 from 2020. I'm informed that the medical and nurse practitioner community are supportive of these technical changes. The other component relates to electronic prescribing. The most significant change to the electronic prescribing laws, which took effect at the beginning of this year, as many of you are aware, would provide some additional exemptions to the requirements for providers to issue those prescriptions electronically. Those include that the prescriber is serving as a volunteer in a free clinic with no remuneration for their services. Their practice is in an emergency or disaster area declared by a federal, state, or local government. They issue 100 or fewer prescriptions in a calendar year. That's total prescriptions, not prescriptions for controlled substances. And that they are unable to issue electronic prescriptions due to circumstances beyond their control. Staff view these changes as not substantially eroding electronic prescribing requirements, and they would likely address concerns raised by some licensees to the board, and as well as I've heard kind of throughout the medical community who just are concerned with kind of the restrictive nature of these requirements currently, and view the electronic prescribing requirements as a burden. Therefore, staff recommend a support position on the electronic prescribing requirements of AB 852, and I'm happy to answer any questions.
Any questions or comments from board members?
Hawkins.
Dr. Hawkins.
What does beyond one's control mean?
It's rather expansive, I suppose, Dr. Hawkins. For a prescriber to indicate that that is their impediment to prescribing, the law would require them to make a submission to the California Board of Pharmacy That would not be evaluated by the Board of Pharmacy, but it would be made public that these are the list of providers who, meet one of these sets of exemption criteria. And the bill requires the providers to maintain documentation to that effect. So, which would then be presumably available to the appropriate licensing board for, an examination, if anything is inappropriate, I suppose, in that regard. But it was meant to be somewhat of a catch-all, but there are, the author's office is trying to put some safeguards in place, in that as well.
Additional comments or questions?
Madam Chair, this is Richard Thorpe. I just have a question about. I use software to prescribe electronically for controlled prescriptions and actually for all prescriptions for that matter. So and it has worked well, and I have no problem with that. But we, as a medical group, we were positioned financially to be able to invest in that software, and I just wonder how this is going to impact the smaller single solo practitioner who, especially in primary care, who may not have the financial resources to invest in this. Is there any? It looks like there's no exemption for that, or there's no consideration of that.
Well, I think this bill might then be of benefit to the providers that you're speaking of, Dr. Thorpe, because if it's beyond their means, it could be lack of consistent internet access if they're in a remote area. And again, to Dr. Hawkins' question, it's somewhat expansive. The circumstances beyond, their control, and it's not well defined. That is not well defined, I suppose. But I think this bill would be at least somewhat mitigating to the concerns that I think I hear you raising. So this is not creating more restrictions, more requirements. This is creating off-ramps, if you will, for providers who are struggling for one reason or another to comply with the current electronic prescribing requirements. Is that helpful?
Yeah, thank you.
Okay.
Additional comments or questions? All right, may I have a motion that, I suppose in support of staff's recommendation, which is the support position?
I move to support.
Second.
Thank you. We've got a motion from Dr. Thorpe with a second from Dr. Hawkins, and now we'll open it up for comments from those in the hearing room. All right, seeing none, are there any comments on the WebEx, John?
Anyone who would like to make a public comment, please raise your hand or type in the Q&A box. Phone-in callers can press *3 to raise their hand. First up, we have Christina Hildebrand.
Hi there, Christina Hildebrand. I'm talking in general about 14A, not just the issue that you just spoke about. I'm curious, I'm looking at what you agreed on, or the legislation that was brought forward in February, which was your last meeting on this, and now the legislation that is here in front of you. And there's a lot of legislation in front of you that is green, which means that you have agreed to support it. But I'm confused as to when you voted as a board to support these different pieces of legislation. So I know I can't get a response from you, but it's confusing to me to see so much legislation that you're supporting, but nowhere in your meetings have you agreed to support this. So are you having meetings outside of this board to determine that? Is Mr. Bone coming up with recommendations and you're just going along with it? But the key piece that I wanted to request is that you change your vote to either a no neutral vote or a no vote on AB 2098. This is a bill that deals with misinformation and disinformation.
Ms. Hildebrand, we're going to be talking about that shortly. So we're going to be going through this legislation one by one. And,
okay, I didn't understand that. Okay, I will hold off then.
Thank you. And for clarity of the record, for all of the bills for which we have a position that are listed in either of the trackers, All of those have come up for conversation and discussion at a publicly noticed board meeting. So the place to find where we took those positions, especially for those 2-year bills, would have been last year. So in 2021,
This is a
it would have
one-year
been at
bill.
one
This
of our
was introduced this year.
Sorry, Mr. Bone, maybe you have a response. And this isn't a discussion, but I want to make sure you have the information you need.
Thank you.
For the clarification for the members, Madam President. Yeah, the bills that are shaded in green are reflective of the staff's recommendations that those bills should be discussed at the board meeting, and the position that the board has adopted, if it already has one, is listed in the position column. So this bill, for example, AB 852, there's a blank where the position is, because this is the first time that this bill has been discussed.
Thank you for that clarification. I'll hold off my comments when you get to AB 2098. Thank you.
Thank you for your public comment. At this point, there are no additional requests in queue.
Okay, thanks. We'll bring it back to the board. So this is AB 852. Any further comments or questions? All right, Ms. Moriarty, if you could please call the roll.
Dr. Gonadev?
Aye.
Mr. Brooks?
Aye.
Dr. Hawkins?
Yes.
Dr. Hilzer?
Yes.
Ms. Lubiano?
Yes.
Yes.
Dr. Thorpe?
Yes.
Dr. Sy?
Yes.
Mr. Watkins?
Aye.
Ms. Lawson?
Yes. All right, thank you. That motion carries. We're moving on, I think.
1636?
1636.
Thank you.
Thanks.
The board heard this bill in our February board meeting and adopted a support if amended position. Since then, the bill has been amended to the point that some of the board's requested amendments are now obsolete. To provide a brief overview of the current language, there are 3 provisions of the bill. The first deals with licensure denials and allows the board to deny an applicant who was previously disciplined by a licensing board, regardless of how long ago this occurred, for sexual misconduct that would be equivalent to a violation of either Business and Professions Code, Section 726 and 729, which relates to 2 different types of sexual misconduct. The second section of the bill, the second of 3 sections, adds to the board's requirements to automatically revoke a physician if they are convicted of a sexual crime in another state that, if it were committed in California, would have required them to register as a sex offender here. The third section prohibits the board from reinstating a licensee revoked under any of the following circumstances: that the license was surrendered or revoked after a finding by the board that they committed sexual misconduct, they were convicted of a sexual crime in California or in any other state that, if it were to require registration as a sex offender in California, and if the crime involved certain current or former patients or clients. And certain misdemeanor convictions are exempted from this reinstatement prohibition, as well as the automatic revocation requirements I mentioned a moment ago. The bill also deletes a pathway for any individual revoked due to a sexual offense to petition the Superior Court to have their license reinstated. While the automatic revocation provisions of the bill encompassed almost all sexual criminal offenses, the licensure denial and reinstatement provisions seem to reflect the author's desire to largely focus in on reducing or eliminating the possibility of reinstatement to physicians who engage in sexual misconduct with their current or former patients or clients. Again, while the updated direction of the bill made some of the board's previously requested amendments obsolete, staff recommend updating our support if amended position as described on the final page of the analysis in order to do the following. 1, clarify that a license surrender following an accusation of a violation of BPC Section 726 or 729A disqualifies that individual from having their license reinstated. Clarify that the restrictions on reinstatement petitions apply to surrenders and revocations that are effective on or after the effective date of the amendments to this law. And third, ensure that the board is required to deny a petition for reinstatement to a physician and surgeon whose license is revoked pursuant to Business and Professions Code Section 2232. That concludes my remarks, Madam President. I'm happy to answer any questions.
Thank you, Mr. Bone. Questions or comments from board members? Dr. Thorpe?
So, Mr. Bone, could you clarify, excuse me, Would this be, is this retroactive? I mean, if this goes into effect, someone who currently has a license in California but was not previously disciplined for out-of-state sexual offense, their license would be in jeopardy of revocation?
I'm not aware of any retroactive provisions. It's generally not how statutes work, and this bill does not call for that. The reason for the clarification that staff recommend, which was something that the board adopted last meeting, is it just helps to provide, I think, clarity for the public and for stakeholders. And so that's the request there, not that there's a risk of the board going backwards in time and kind of applying this new standard to facts and circumstances that occurred previously.
Thank you.
Mr. Watkins, I saw your hand.
Hi. So I just have some clarifications. My first one is under petitions for reinstatement. The third one, the person has been required to register as a sex offender, which triggers this law, except for certain misdemeanor convictions. If the crime, here's the deal, if the crime involves certain current or former patients or clients, I would like to know, do colleagues fall within that client definition? Because it feels very narrow. It seems, and I just want to get the definitions right. So in the case of where a physician is, convicted of sexually assaulting a colleague, would this law then be triggered if they come for a petition of reinstatement, or is this so narrow that it excludes that, or any normal person?
I'm advised that it would be excluded. It's excluded to clarify, the permanent revocation requirements, or rather the prohibition on reinstatement, to be more technical, would only apply to those who have been who have that that sexual misconduct with a current or former patient. So yes, a colleague, somebody who, we can imagine, right? Like lots of people that would be left out of that. Those individuals would still be eligible to petition the board to make their case with clear and convincing evidence that they've been rehabilitated.
Can we add that as an amendment in our ask, just to expand that? Because when this may be open up a discussion, I believe that if someone is convicted of sexual assault on anybody, that substantially relates to the profession. And I think it needs to be seen in the same light. And that was also the guidance that was provided when we did the FSBC sexual misconduct training in 2020. That was one of their recommendations, that we don't separate that out. And that's why I'm asking for that to be amended.
That is the staff's position, Mr. Watkins.
Okay, perfect.
Yeah, and so I apologize for somewhat of the technical nature for the recommendation, but that reference, the third bullet in the staff's recommendation to BPC 2232, that is the code section that requires the board to automatically revoke an individual who has one of these sexual misconduct crimes for which they are guilty. So that's the board's position. The staff's position is consistent with what you just described.
So just to clarify, so that would include all the sexual misconduct regardless of that specified arena, because that is like an escape clause if you think about it. If someone comes before the board, we see it again, they are petitioned for reinstatement, and that particular line says the public, and suddenly we open that little door, and then that can be very convincing when they come before the board because it didn't fit within this narrow definition. I'm concerned about that just because of the cases that we see. When it gets really narrow, our hands are tied.
I will confess. Thank you, Mr. Watkins. I will confess that the code sections that deal with this area of law, particularly when it gets to the penal code, are exceedingly detailed, and I can't give you a comprehensive rundown of all of the different various types of sexual crimes that are encompassed by the automatic revocation. Like I said, there are some exceptions that are current law. To my knowledge, those are in kind of the lesser misdemeanors. But I think in general, if you have committed a crime that is going to land you on Megan's Law, which is the sex offender registry in this state, that generally you're going to be revoked under this law. And the staff's recommendation is consistent with what I understood you to just articulate, is that if that's the case, then you would be prohibited from coming to the board and seeking reinstatement.
Okay,
Is that helpful, sir?
Yeah, yes, that's helpful if it actually works that way in practice, because and this is just what I've seen based on experience. If there is such a loophole, I'm very careful with legal language these days, because when it's that narrow, it becomes, our hands are tied, and then we find ourselves in a situation where someone do appear before the board again, and they say, well, we don't fit within that definition. We are on the sex offenders list, but we've had our record expunged, and, we have a certificate of rehabilitation. We've done all these things. They make a convincing case, and that little section there that specifies very clearly, that is the escape clause. And I just want to make sure that we can actually address that, because that will give this actual bill a lot more. It will focus it and zero it in to achieve what I think it sets out to achieve. And this is a good first step.
So I think to your point on the certificates of rehabilitation, I think was the phrase you used. To my understanding, those only come into play when you have a application situation. But if the individual has already been licensed at the time that they're disciplined or have a criminal conviction that we're speaking of, the bill does not allow, that I see, the bill does not allow for the person to use their certificate of rehabilitation if they were to receive one from the court or through some other process, that's not a pathway for them under what the staff and you are proposing, the way that the bill be amended.
Can I just make a clarifying question? Because my understanding is staff, we don't feel like this goes far enough, exactly to Mr. Watkins' point. And so our support, if amended, position is contingent on them making these amendments such that it actually goes farther, just like you're requesting. So I think we're all on the same page about how to push this.
I apologize if I delved into the weeds a little bit too much there, but yeah. And the other matter with regard to strengthening, the provisions of the bill has to do with this matter of, surrenders. As the board is aware, surrenders often don't go through the board. They can be handled by the executive director. And if there is an accusation filed and then a surrender occurs, what can happen is there may not be an admission, right, from the individual. And so a very important part we see of the staff's recommendation is to seek that if there is an accusation and then following that, regardless of an admission, that there is a surrender, then that would also cut them off from seeking reinstatement.
Okay, and my second clarifying question is, and this may be addressed, but I didn't quite understand it. So right now, if you end up in the sex offenders list, I'm just looking at what we get when we adjudicate over a case. We get into the room and, an applicant comes for a petition to reinstate, and they've satisfied all the conditions. They've even expunged the record, so that documents are sealed, but I don't think that they can get off the sex offenders list. But when they expunge the record, it actually strengthens their case if they show enough rehabilitation. Will this law as it stands, and I'm just asking for advice, as it stands, will this seal that? Because that's very important, because if they do come in, and that's still a pathway, which it is for many of our other cases, if it's a pathway, I would like to suggest that we close that pathway. And I think this addresses that, but I'm not sure. So maybe somebody can clarify that for me.
Mr. Watkins, I think you're hitting on the points that staff recognized and strongly believe that now is the time to get these protections in place and that this is the vehicle to do it. And you're absolutely right. There are people who commit sexual misconduct and then are able to get that expunged. And AB 2138 that passed a couple of years ago that the board opposed means that we can't consider that. Yeah. And I think that the legislature and the public are recognizing that the board needs more tools in this area of sexual misconduct. This is a tool that can be made better, and again, now is the time. And so staff recognize that they don't have the language quite right with regard to surrenders, and so there's a fix for that. For whatever reason, there is an exemption for someone seeking reinstatement that if they committed sexual misconduct with a family member, with a colleague, as it's currently worded, they could seek reinstatement from the board, and staff feels that that is not appropriate considering what Assembly Member Weber, what we think she's trying to do here. So staff recommends that that loophole be changed. So if you've committed sexual misconduct with anybody and you've been revoked or you surrendered with an accusation pending with those allegations, that bars you from seeking reinstatement.
That clarifies everything. I'm glad you clarified it that much. Thank you.
You're welcome. Mr. Brooks?
Two questions. So on the application for reinstatement, usually I'm going back to my board of pharmacy, there was a checklist that you had to attest to. And one of them was, have you been criminally convicted of sexual misconduct or a crime as part of the application for reinstatement? From what I understand with the legislation, it doesn't say it has anything to do with it being expunged or not. It says, have you been convicted? And the convicted means, I don't care if it's been expunged. Is that correct? Am I interpreting it wrong?
Well, there's a difference between board forms and what is in the law, and ultimately the law controls.
Yeah. But on the law part, the law just says, have you been convicted, period, and it has the categories. If it's expunged or not, why does it matter?
Because AB 2138 says that we can't consider an expunged conviction, and
in an application, in a licensure application setting, but I think understood Mr. Brooks was asking about a petition situation.
But that's also a factor for reinstatement that has to be considered. And what staff wants to say here is that if you've been surrendered or revoked for sexual misconduct, you are not eligible for reinstatement, regardless of who the victim was.
No, I get that part. I completely understand it. I'm saying when you go to application for reinstatement, there is a box that gets checked that says, have you been convicted of any crime in the last 10 years or whatever that may be. If they check the box no because it's been expunged, they're lying, right, on their application process. Is that correct? If you have been convicted,
if they check no, then that is not honest.
Yeah, so we would reject that outright or we could reject it outright. Is that correct?
For a dishonest statement, yes. I think that's a potential.
Okay, this is something we just might want to look at a little further. That's the only reason I bring that point up. And then second, what happens when you have a medical student who is convicted of sexual assault that meets these criteria? Would this law prohibit that student who's doesn't have their license yet from getting a license? Or is this only for reinstatement of doctors who currently hold a license?
So the bill is largely focused on individuals who are already licensed. For a medical student who's never been licensed previously, then the laws that were changed a few years ago under Assembly Bill 2138 would be the controlling area of law. And so depending upon the length of time or the seriousness of the crime, then the board could use their criminal conviction history as a reason to deny their license.
So it sounds like, and I haven't read the previous laws for people, students who don't have a license, it sounds like the legislature is saying it's okay if you can get your license if you, as a student, if you had been convicted of a sexual assault, but if you're looking for a reinstatement, you can't get your license. Is that correct?
Well, I just think that the legislature's already done a lot of work in that area with regard to, criminal conviction history. And so, certain crimes, if they are serious enough, can always be a cause for denial, regardless of how far back it occurred. Generally, it's 7 years is what's referred to as the washout period. But for serious crimes, and depending on what you have in your mind, that could meet the definition of a serious crime under current law. In which case, then the board could continue to use that regardless of how long ago that was.
I don't want to beat a dead horse, but maybe I'm not being clear. So currently, this bill that's being proposed, if you've been convicted of such sexual misconduct, you're on Megan's Law. You cannot petition for reinstatement, correct?
The bill states that if you have been convicted of most sexual criminal offenses that and if they involve a current or former patient, then you may not seek reinstatement.
Okay. And so, but if I don't have my license yet, I'm in the last year of my medical school and I've been convicted, yeah, I'm okay to get a license.
The board has the option to deny you.
Okay. All right. Thank you.
If there's anything Ms. Webb wants to clarify with that.
Unless it's been expunged.
Yeah.
And that does happen, which
we should just maybe think about an amendment to this bill to capture that loophole, because if you're convicted of a sexual crime an hour before you get a license or an hour before you're asking for reinstatement, the crime's the same and the policy should be the same.
Well, I think, the board deals with things on a case-by-case basis with application situations. I would imagine if I heard you correctly, an hour before your application, then, there's probably not a lot of time to show that you've been rehabilitated from that, and a denial is very likely, but I understand, I take your point.
Yeah, but the current bill is not about rehabilitation. It's saying if you've committed a sexual crime and you're on the Megan's list, you cannot apply for reinstatement, period. And so with the current system as I know it, it says if I don't have my license today, I can be rehabilitated for the same crime as that person who's petitioning for or being denied their petition for reinstatement.
Yes, the bill does. I take your point. Yes, the bill contemplates a handling differently the individuals who have yet to be licensed versus those who are licensed already at the time when they, commit their sexual misconduct. That's what the bill does.
So if you're going to commit a crime, just do it before you get your license, and you're okay. It's kind of how it plays out, being facetious.
No, and Mr. Brooks, I mean, your point is well taken, but I think there's two different sets of circumstances that are being addressed there, right? And frankly, I don't think that there had been a problem identified in the licensing capacity, right? Where those who had been convicted of sexual misconduct were getting licenses in the first instance, right? The problem we're trying to solve, and Dr. Weber's trying to solve through this bill that we support, is solving that loophole that a physician who's been licensed has committed misconduct, and then they come back before the board And the board, through its disciplinary panels, feels hamstrung, right, and limited in terms of whether or not we need to give that license back. And so that's the problem this one's trying to identify, not to dismiss the problem you've also identified, which is we should perhaps solve that loophole, but I'm not sure this bill, which is addressing a specific problem, is the vehicle for doing that.
Well, I mean, this bill right now is actually the vehicle for doing that because it's germane to licensures of physicians who are convicted of sexual assault. I mean, you can't get a more germane bill. And the reason why I bring that up is if we have an opportunity for amendments to put in this bill, that's an amendment that I would put in. The author could reject it. I get it, I understand it. But if we're looking for, patient safety right now, just because you don't have your license yet doesn't mean that crime is any less serious.
I think that I think that the board staff that reviews applications and something like this would go through senior staff. If there's a recent conviction for sexual misconduct that has not been expunged, and that expungement takes a while, that license is denied, or there's some other safeguards put in place. So I hear your concerns. I do think that is appropriately addressed. It's the older sexual misconduct cases that prior to 2138, the board had more flexibility to deny, even if they were expunged. But I think that any recent conviction that would result in a denial, that tool is still available to the board. All right, just a minute. We have got Dr. Helzer, Dr. Devin, I'll come back to you.
Thank you. Mr. Bone, during our last meeting, you described a potential conflict between this bill and existing law that governs how we consider an applicant's criminal conviction history when they apply for a license. Have those concerns been addressed?
It has It was resolved, I think not quite in the way that the board was hoping for, but what the conflict that you mentioned was between the statute that we've been talking about under BPC 480 was amended by this law, AB 2138, from a few years ago. And what we pointed out at the prior meeting was that current law might override some of the new provisions that we're seeking to be introduced through this bill. And we said, well, this bill should override BPC 480. Well, the legislature kind of did it the other way. They had BPC 480 almost, if you will, override this. And so what they've done is the bill proposes to amend BPC 480 to allow the board to use a sexual misconduct discipline from another state, irrespective of the length of time, that can always be used as a reason to deny an application. So the conflict was resolved, but just maybe not quite the way that we contemplated.
Thank you.
Dr. Devin.
Thank you. Aaron, I gather this bill applies to both MDs and DOs. That's about it. Is that right?
Yes.
The other healthcare professions, it's a huge issue too. Are there already laws whether it is pharmacy, nursing, or I'm talking about serious healthcare professions, is there a law or it's not there, this is the beginning?
I couldn't tell you what exists in the PA Practice Act or the Nursing Practice Act. What I believe is kind of to the discussion that was happening a moment ago, that the author's focus, she is an OB, she's a licensed physician, one of our licensees, an OB/GYN, and I believe it's fair to say that her focus in this is physicians who violate that ethical boundary. And that, she's trying to have a very narrow approach to, the particular problem that she sees.
Okay, I mean, my preference will be have these strict rules for any healthcare licensees, because it is somebody puts their life in your hands and you do this stuff, and it doesn't matter whether you are a doctor, a nurse, or a pharmacist. So,
Thank you.
I know this, we can't do anything with this. This is strictly very narrow to the physician surgeons.
It is, yeah.
Thank you, Mr. Watkins.
Yes, I'm listening and I'm thinking that the loophole that Mr. Brooks refers to in this deal, since this bill addresses that, I would rather, have staff develop, ask for that and allow the legislature to say no, because I don't think that we will have another opportunity to address this, and I'll give my motivation for that. Because if a new applicant comes before the board, and I think Marina, could add to this, and they just pass the 7 years, or they come to the 6-year threshold, and they apply and they get denied. They apply and they get denied, but they don't give up. At some point in that process, because every time an applicant applies, the application gets stronger and more compelling, and it creates like pressure from our side to look at that if it's not as egregious, and we say, 7 years have passed, and say there was a restitution made or this, that application gets to look really good to the board to give that applicant probationary license, and that enters the system. And I believe that that is a loophole. So if we could have an amendment that addresses that, then that would be useful. And the reason why I say that, it may not be big numbers, but even this law, it has its limitations, because this issue is broader than that. It also addresses very few numbers in a year. That LA Times story only documented over years that how many physicians have gone through this process. And I'm just saying, if we're going to close the loophole, close it right through all the ranks. And that's why I would love to see some language to this amendment that that Mr. Brooks has suggested, that we close that down and include applicants and the limitations to entry to the profession for them as well, and see what the author says.
So to clarify, because I'm reviewing BPC 480 right now and Penal Code Section 290. So there's already law that would allow for, again, for individuals who have been convicted of serious sexual offenses. A licensing board may always use that as a basis for denial, irrespective of how long. But what I think I understand, so to clarify your point, Mr. Watkins and Mr. Brooks, is that you would be seeking an amendment that would state that any sex offense, any sexual misconduct, criminal offense, period, can always be used as a basis for denial, irrespective of the amount of time since their conviction. Is that?
I would mirror exactly the language that's there right now.
Excuse me?
I would mirror the language that's currently being proposed right now, just in addition to not people petitioning for reinstatement, for applicants or someone who does not yet have their license.
You'd like the language to state that they may not apply for a license, and we are prohibited from granting it.
Yeah, so keep the language exactly the same, but just include a new category for people who are petitioning.
So the bill speaks to convictions pursuant to subdivision C of Penal Code Section 290, which encompasses many types of sexual offenses. I couldn't give you the list. But that's the reference that it sounds like you're trying to tie to license denials.
Correct. I mean, I'm not trying to change the categories at all.
Yeah.
I'm just saying the same should apply to someone who doesn't yet have their license, because the crime is the same. And just because you don't have your license doesn't means it's better. You can just spend 7, 8 years going through medical, school, And all of a sudden that 7-year kind of window goes away. The crime still has been committed, you still have been convicted.
And that, just one more clarifying point, this would be to allow the board to deny somebody or to require the board to deny an application?
It would be required, the same language as currently, and the proposed legislation would not change. All we're adding is someone who has not received a license.
So am I correct that that's exactly what was amended out of the bill?
Yeah.
Since the last meeting?
Oh.
Yeah.
I can go back and take a look.
I'm just rereading
I'm sorry, I didn't know it was moved out of the bill.
Well, I'm just rereading the analysis here. This is not an issue I had focused on in this level of detail previously.
Yeah, you would have been, under the introduced version of the bill, we would have been required to deny if they were convicted in any court in or out of this state for any offense that would have been punishable under subdivision C of BPC 290, and they engaged in the offense with a patient or client or with a former patient or client. Paragraph does not apply to an applicant.
Let's do this. Why don't we hold on this thought? Let's open it up for public comment, see what public comment gives in. That'll give staff a minute to take a look at this too, and we can bring it back for discussion if that makes sense. Okay, is there any public comment in the room? All right, seeing none, Sean, if you could open up the line, please.
Anyone who'd like to make a public comment, please use the raising hand feature or type something in the Q&A box, and any call-in users, you can press *3 to raise your hand. First up, we have Dennis Cuevas Romero. Dennis, you should be receiving that request.
Dennis Cuevas Romero with the California Medical Association. We are the sponsors of AB 1636. Want to just show our appreciation to the staff and their thorough analysis on the bill. We have had conversations with staff via the legislative process on this bill, and really appreciate the analysis. We intend on working with the legislature and medical board staff in addressing some of the comments and suggested amendments moving forward. So that is the commitment from CMA to continue the conversation. Just want to comment on a couple of the issues. On the retroactivity question, that is not at least the sponsor's intent. I think we'll be happy to work on drafting an amendment to make that clarification. Again, this is not our bill. This is Dr. Weber's bill, so I don't want to speak for the author, but I think that's something that we can do. As for this conversation regarding this last point, regarding pre-licensure denials, that was a challenging conversation with the Assembly BMP committee because of the legislature's effort to allow for rehabilitation and the consideration of potentially treating someone that has been convicted of a crime, let's say at the age of 19, as a young adult, and allowing them to potentially rehabilitate themselves versus a physician that understands their elevated ethical and professional responsibility that then gets convicted of such a crime, and essentially treating those two the same. And the legislature via 2138 a couple years ago has made that I think decision to change that and allow for rehabilitation in those instances, as was properly addressed by Mr. Bone. That was in the initial draft of AB 1636, but that came out in negotiations with the legislature and Assembly Business and Professions Committee.
30 seconds remaining.
So just wanted to say we will continue to work on the bill to address the medical board's suggested amendments, and we appreciate the supportive amended position. Thank you.
Thank you for your public comment. Next up, we have Dr. Hannah Reed. Should be receiving that request on your end. Try one more time here for Hannah Ree.
Yes, my apologies. I don't have a question or statement.
Thank you very much. Next up, we have Marion Hollingsworth. Marion, let me send you that request.
Hello, can you hear me?
Can, Marion, go ahead, please.
Thank you. Good morning. My name is Marion Hollingsworth, a patient safety advocate. Regarding AB 1636, excluding any victim who is not a patient is not protecting the public. Non-patients are California consumers as well. So under this new version of AB 1636, a doctor could have been convicted of being a serial rapist and still petition for reinstatement if he didn't have to register as a sex offender, and a doctor who was revoked or surrendered for victims who were not patients could also petition for reinstatement. Am I getting this right? I feel this bill should include colleagues, next door neighbors, or any victim. Anything short of that is a disservice to women in particular, since women are usually the victims, although there have been cases with men victims as well. I think it's wrong to have the CMA write this bill in the first place, since their sole purpose is to protect doctors and not patients. I've tried to speak with Dr. Weber about 1636, and she is my actual representative, and there is no interest in speaking to advocates or members of the public. I agree with your concerns about victims, and I urge you to push for this change in 1636 to include all victims. Thank you.
Thank you for your public comment. Up next, we have Eric Andrews. Should be receiving that prompt on your end.
So just remember that this board can only consider rehabilitation of doctors if it's in the best interest of patient safety. You can't consider rehabilitation without that vital component. So when they talk about, oh, let's talk about rehabilitating doctors, if patient safety doesn't come into play, you can't consider it. Look at your mission statement. Look at what the law says. You often bring up this rehabilitation thing as if it's a first priority. It's not. It has to be only with patient safety in mind first. I agree with Deb that this should cover all healthcare specialties. What is it about MDs and DOs that single them out as being worse than any other healthcare profession? Anybody who sexually assaults any patient, colleague, neighbor, anybody should be considered in this bill. To be anything else is just weird. It's a discriminatory. Also, going to the public before you finish discussion prevents the public from commenting on what you're going to say when you resume. So this is kind of an unfair place to put this public comment section when you haven't even finished talking, because if something comes up now after this point, we won't be able to comment on it. Thank you.
Thank you for your public comment. Up next, we have Virginia. Virginia, you should be getting that prompt there on your end.
Thank you. I agree that it should be all victims and not just a select amount of victims. And it should be all practitioners, not just doctors. Never mind. But anyways, it should include all, including chiropractors. And we need to do something like this for surgical assaults and letting people bleed to death for 5 to 10 hours. So it should include stuff, not this bill, but we need a bill for those actions as well. Thank you.
Thank you for your public comment. This time, I don't see any additional requests in queue.
Thanks, Sean. We'll bring it back to the board.
If it's helpful, Mr. Brooks and Mr. Watkins, just refreshing my memory on the current licensure denial law. So there is this BPC section 480, but then there is a law that's particular to the Medical Practice Act as well that states the board shall deny a physician or surgeon certificate to an applicant who is required to register pursuant to section 290 of the Penal Code. So if somebody comes to us right now and they have an active Megan's Law registration, then the board denies their application. In addition to the other options that are available to the board under BPC 480. Just wanted to just put a little bit of added color.
I appreciate it. Thank you.
Well, for me, is that actually doesn't hold when that process continues down the line. And with this law, the process will hold. And my sense is just that if you are in the interest of public protection, as one of the callers raised, that's our mission, right? So if at the first stage, we always deny if there's grounds. The second stage, not so much. Third stage, from most of the times we'll give it. And so this law affords us the first time the opportunity to just close it down and put everybody on the same level, because the standard that we're trying to meet is public protection. So I agree, we do have the laws to deny the first time, and we actually do that very, very efficiently. It's when the second time comes around where things get softer, and the third time. And what if there's a law like this that holds right through? Now you've just prevented someone that could be potentially dangerous to enter the profession. And that's why this will hold. And that's why I would still, petition for that amendment, regardless of what everybody else says. Let the legislature see that we are serious about protecting the whole thing, and allow them to remove it again. Let's keep this conversation hot, because once we leave this opportunity, it's not going to come around again. So that's safe to say. Thank you.
I didn't mean to speak over you, sir. So then perhaps to kind of effectuate that change, then that language that I read from you, perhaps then the amendment that I hear is that we would be seeking that, if this is the motion, that if at any time the individual has ever been required to register as a sex offender, then that individual shall be denied a license.
So my understanding is that we would be asking for a reinstatement of the language that was in the prior version of the bill. Applicant is or previously was required to register as a sex offender, excluding misdemeanors.
In many ways.
Yeah.
In many, maybe not to, every, dotted I or crossed T, but I think the effect would be pretty comparable.
Right. So just for purposes of what the motion would be, because staff has recommended a support if amended position with 3 specific bullet points. They're on page 5 of this analysis. It would be to add a 4th bullet point to that on this issue of a requirement for denial of an application for licensure under the circumstances that you've been discussing.
So I'll move to add that language as a support if amended, and those being the amendments.
Can I just get a sort of nodding of head? Great, thank you. All right, so we have a motion from Mr. Watkins with a second from Mr. Brooks. I think we're ready to move unless there are further comments. Ms. Lubiano?
Yeah, that's what I was going to ask, please.
Yeah, so the motion on the table is a support for the board to adopt a support if amended position with the amendments that were requested by staff. They're on page 5 of the analysis, and I'll just read them. To clarify that a license surrender following an accusation of a violation of BPC 726 or BPC 729 disqualifies an individual from having their license reinstated. Also to clarify that the restrictions on reinstatement petitions apply to surrenders and revocations that are effective on or after the effective date of the amendment statute, and to ensure that the board is required to deny a petition for reinstatement to a physician and surgeon whose license is revoked pursuant to BPC section 2232. Then to add a 4th bullet point, which would, I guess apply the provisions of the bill, also to require denial of an application for licensure under the same circumstances.
Who's ever been required to be registered as a sex offender?
Correct.
Pursuant to PC 290.
Yeah, I mean, under the same circumstances under which the bill would require us to deny a petition for reinstatement, that those would be.
Well, so there's a little bit of difference then between what I heard a moment ago. So if we're talking, So if we're trying to modify the requirement for the board to deny anyone in perpetuity who has ever had a PC 290 registration, that would be more restrictive than pegging it to the automatic revocation, which speaks to a little bit slightly smaller subset of sexual crimes.
Well, I guess the point of the amendment is to mirror the current language that's proposed in the current bill.
Okay.
All we're adding is if you're applying, you don't have your license yet, and you fit all the criteria that's in the current bill, the same effect happens.
Okay, thank you.
All right, are we ready to proceed to a vote on this? All right, Ms. Moriarty, please call the roll.
Dr. Hawkins,
Yes.
Dr. Gonadev,
Yes.
Mr. Brooks,
Aye.
Hilzer,
Yes.
Ms. Lubiano,
Yes.
Mr. Rue,
Yes.
Dr. Thorpe,
Yes.
Dr. Sy,
Yes.
Mr. Watkins,
Yes.
Ms. Lawson.
Yes. All right, thank you all. I think we're moving on to 1662.
Find my place. Thank you.
Is that right, or is that?
Yes.
Okay.
Yes. Thank you. I just had to shift my screens. 1662 is a bill that would require the DCA licensing boards and bureaus to provide a pre-application determination to a possible future applicant for licensure as to whether their criminal conviction history could disqualify them from licensure. The board adopted a support if amended position on this bill during your prior meeting. Since that time, the requirements of the bill have been updated and were provided some additional details on how this process might work. Importantly, the language does not require boards to provide a binding determination on whether their criminal conviction history will cause the licensure application to be denied. This satisfies the first concern raised by the board in its support of amended position adopted at the last meeting. Unfortunately, our concerns related to costs have not yet been addressed. The bill as drafted only allows the board to charge a $50 fee, which seems to likely include the $49 cost that we must pay to the Department of Justice and FBI for fingerprinting processing expenses, leaving as little as $1 per application for our staff costs to cover IT, rulemaking, and staff time associated with reviewing these requests. Therefore, staff suggests the board update its support of amended position and to request the following amendments. One, to clarify that all costs associated with the all costs associated with the requester's fingerprint analysis are borne by that individual. And secondly, to remove the $50 maximum fee amount so that the board may charge any fee amount necessary to cover the board's reasonable costs associated to establish and administer this program. Happy to answer any questions.
Thank you, Mr. Bone. Questions or comments from board members? Dr. Helzer?
Mr. Bone, do we have an estimate as to what a reasonable fee would be for this procedure?
Well north of $50.
How far north?
Yeah, a few orders of magnitude greater than $50.
You mean several $1,000s?
No. I mean, couple $100 range, thereabouts. It's difficult to give an exact number until we kind of embark on the rulemaking process and kind of figure out all the different contours about how that, process would look. As I mentioned earlier, $49 goes right off the top for fingerprinting costs. So if, in terms of the staff time alone, as well as to reimburse the staff's costs, there's certain one-time costs for rulemaking and IT and that sort of thing. But the ongoing costs could be, could necessitate a, $200-300-ish. Don't hold me to that, please. Fee amount.
Thank you.
Yeah.
Dr. Gonadev?
Yeah, I think $50 is ridiculous, but reasonable thing from any government agency is very worrisome. So you do need to come up with a number. I think and convince us that's the number we want. So rather than reasonable cost, I mean, now we don't even have reasonable application fee for the licensing. So that's why I think it is important to come up with, otherwise it will, I doubt it will go in legislature anywhere with that language.
So sometimes fees are set in statute, as you know, Doctor, and sometimes administrative agencies are given discretion to review. So the bill right now sets a ceiling of $50, but there's no floor. So that language is already in the bill that speaks to reasonable costs. The board would have to do a rulemaking in order to get this program, up and off the ground. And in the course of doing that rulemaking, we would have to provide a robust analysis and evidence to defend whatever the proposed fee amount would need to be. It's just not the sort of thing that we can, pick a number out of the air. There needs to be a substantial amount of evidence to defend that cost.
So do you think we can come up with that number before the next step in the legislature? I mean, there will be a ceiling. I'm just asking, do you think we can come up with a number for the ceiling where our costs are covered?
I think staff can work to provide a more precise number if, that's the direction of the board. Yeah.
You could do it not to exceed a number.
Right.
Might make it easier.
But that's what I meant.
Yeah.
So the ceiling has to be higher. We need a reasonable number. The legislators can get convinced that that's the ceiling.
Dr. Harkins, I saw your hand.
Thank you. So I don't want to rehash this, and I may have misunderstood what you just said, Aaron, but it appears that we have a way out with this not being binding, but I wasn't really sure exactly why we're even doing this. It almost seems like a false olive branch. I mean,
why we're doing which part, Doctor?
Supporting this. That is giving the applicant the impression that they may or may not be able to be licensed, or there's some exclusionary factor. It just seems like potentially a lot of work, and I don't remember exactly what we said last time, but it just seems like it's not necessarily a good idea.
The bill presents a challenging prospect, I would say, for licensing boards, which is to look into the future as to how at the time of their application, how might the board look at their criminal conviction history. As we were discussing in the previous item, for most crimes, and I understand this is the bulk of the applicants who present a criminal history at the time of application, those are, drug and alcohol convictions or otherwise going to be subject to that 7-year washout period. So as long as their application comes 7 years after the date of their conviction, and it is for, one of those types of violations, the board is prohibited from using that as a basis for denial. And the bill contemplates the individual being able to request this pre-application determination at any point. Could be days after their conviction or, whatever. They're not time-bound, which, as I've engaged with the author's office on this bill multiple times and have indicated the difficulty that presents us with, which is at the time of application, we're trying to look, and Ms. O'Connor can speak to this more eloquently than I can, but at the time of application, if they have, if something comes up on their fingerprint, we're trying to look backwards as to what evidence of rehabilitation there is. Maybe they did have that drug and alcohol conviction, but they had no issues during their, postgraduate training. Well, that's obviously going to, that could favor, in there as a mitigating circumstance. But to be able to look forward as to how that could be used is very challenging. But the board decided to do a supportive amended position because I think the board was generally supportive of the sentiment, behind that and helping, the author. And there's been, 2138 and these other, bills. The recent policy direction of the legislature is how can we engage these folks and get them back into the workforce, which is laudable. But in this particular circumstance, there's some real challenges.
Mr. Watkins, I saw your hand.
Yes. You see, I kind of agree with Dr. Wilkins' perspective, because what I see is that we are trying to kind of take on some, clarify or mitigate some risk that the applicant has to undertake. And a big part of literally growing up is taking on risk. And sometimes, I can go and apply for, or somebody can go apply for a job, regardless of a criminal record, with a criminal record, and they may or may not get that. And this is a licensed profession, so that level of risk has just increased. Our attempt to mitigate that and go through all that and make all these accommodations, I think will land us into having to literally conduct too much. We'll take on too much cost, and we will take on too much administration. And I don't see that actually protects the public in the long run, because risk is what we will assess when we get that application. What we now require is that we must assess a risk on someone that didn't really apply yet. And I think we're taking ourselves too far back into the process in an area of someone else's personal responsibility. Our responsibility starts when we get an application. And all that precedes that is somebody's own, drive, somebody's own, risk profile. So that's what I agree with Dr. Wilkins on. Maybe a little too late to change that.
Ms. Lawson.
Dr. Gananadeb.
Aaron, just a clarification. Who is this Council on State Governments and Justice Center who are sponsoring this? Just curious what the interest there is.
I'm not intimately familiar with them, Doctor. I believe actually that I think they're going to be on the line and be able to speak during public comment. So hopefully, if they're there and they're listening, they'll be able to kind of give you some additional background on their organization.
Yeah, but because my other thing is, why did this even come up? So because if we can't give them an absolute answer, what is this going to add? There are a lot of things which we can't understand. I do get that, because licensees do not want a denial, because they have to declare that with another state wherever they are, and sometimes the other states take disciplinary action if the license was denied. But that's why I was just curious who the sponsors are and what's going on. Thank you.
Well, just a few comments from me, because I do think that the objective of this legislation is laudable, right? I mean, the intent is such that is that criminal convictions from your youth, for example, not hang over your head for the absolute rest of your life, right? Now, with the previous bill, we talked about a certain type of criminal conviction that should be disqualifying, right? But there are a variety of criminal convictions that, in my personal opinion, should not be disqualifying from being licensed 10 or 20 years later, right? Once a variety of circumstances have occurred. And I think what this is attempting to do is give certain applicants confidence that they can invest in themselves, invest in a medical school education. Frankly, this is not really targeted at the Medical Board of California, where I think there's a very small subset of applicants who would meet these criteria. It's really targeted at all of the DCA boards, right? And there are, someone in the room will know exactly how many there are, but I think it probably applies in other contexts, frankly, more than it applies for the medical board. I was looking at the staff analysis. In 2020 and 2021, the board received approximately 53 applications for physician and surgeon applicants with a criminal conviction history, 29 postgraduate training license applicants. To other applicants, the board did not deny any applicants for licensure during their due to their criminal conviction history in fiscal year 2021 or 2019-20. The board denied 2 applications related to the applicant's criminal conviction history in fiscal year 2018-19 and 5 in 2017-18. So that's the scope of what we're taking a look at. But I do want to, I think that a support, if amended position is the right position for us, because frankly, I do think we should be supporting these people and giving them every opportunity to, really reintegrate and participate in society in a meaningful and productive way. Mr. Rue?
Thank you, Madam Chair. Mr. Bone, was this the issue where staff originally recommended oppose if amended, and then we flipped it to support if amended? Was this the same one?
Yes.
Yeah, so what I could recall from discussion was, and I think our chair was making all the right points. I think this really, in the staff analysis, it shows that it really does not affect our board as much. And I think it's very minimal on the number of applicants, right?
Yeah, I think President described very well the data there.
And I remember the author of the bill called in, and the intent was for social justice reform. And I think it deals more with like board of cosmetology, barbery, those boards where there's a lot more applicants, where before they invest in getting educated, they wanted to make sure if they were going to be able to qualify and not know at the very end after they spent all the time. So I remember that's why we said support if amended, because we had a lot of concerns because there's a lot of unknowns, and I know the author was willing to work with us. And I thought we even talked about possible exemption from this because it doesn't really affect us as much, right?
We did. That request did not occur.
So
didn't get agreed to.
Yeah. So I concur with the chair. I think the right position is support if amended, and as Dr. Ganadev said, if we could somehow give a ceiling, I know it's really tough for you guys to make that analysis, but even if it's a maximum of $100 or $150, or assess other boards to see what they charge and find the highest one, and try to advocate for that, or I don't know, some other analysis you could come up with.
Yeah, we'll see what we can do when it's a new process. Sometimes that poses challenges, and looking to some of the other boards is difficult because again, they're going to be creating this new process at the same time as we are, and the beauty of the boards is we're all different, right? Doctors and cosmetologists, and runs the gamut, right? Every board is different, and these bills are attempting to overlay a one-size-fits-all, if you will, process over all the unique idiosyncrasies that each board has.
And I concur with some of the colleagues here because honestly, I think the odds of the amount of work we're probably going to put into developing this is probably we might get a handful, if any, of people who even inquire, right, if they qualify or not. So it really might be more work than it's worth, but I think the intent is laudable, and I think we should try to support it and try to work with the author on this. Yeah, no, and we've had a lot of good, positive conversations, unfortunately, regardless of the amount of applicants, requesters we may receive, so the statute says we shall do this, then, we shall.
Thank you, Dr. Hawkins.
Dr. Hawkins, I agree with the President's comments.
Thank you. Are there additional comments or questions before we move to public comment? I think often we do a motion right before we move to public comment. So it's open for discussion. Do we have a motion to support staff's recommendation?
Motion to support staff's recommendation.
Do we have a second? Second from Dr. Canada. Thank you. All right, we'll open up for public comment. Is there anyone in the hearing room that wishes to comment? All right, seeing none, we will go to the WebEx. Sean, please.
Anyone who would like to make a public comment for this bill, please use the hand-raising feature or type something in the Q&A window. First up, here we have Josh Gaines. Josh, you should be receiving a request on your end. Unmute.
Thanks for the opportunity. I'm Josh Gaines. I am with the Council of State Governments Justice Center. I'm a project manager on our economic mobility team, and we've been working closely with the Assemblymember Gibson's office on this. Since it was raised, we're a nonprofit, nonpartisan organization. We serve states across the country. That the states are actually our members. All 50 states are members of the Council of State Governments. And what we specifically do is provide data-driven technical assistance on justice issues for people at all levels of government. For several years, we've been working with states across the country to expand opportunities for occupational licensure for people with criminal histories, and trying to do so while also maintaining public safety, which obviously is the primary concern of the boards. And, you know, as everyone said, this is really aimed at reducing risk and allowing more people to come into the profession and you know, to maybe go against something that might be helpful to the argument we've been talking about cost. But ideally, with a process like this, you would be seeing more applicants with criminal histories, right? Because that's the entire idea behind it. If you have a criminal history, you can get a determination sooner rather than later, instead of foregoing, you know, a medical degree, for example, or a cosmetology degree, right? A landscaping, whatever it may be, so that you can, you know, feel comfortable getting the education and then getting to a point where you can apply for licensure. And I'm just looking at my notes here because I wanted to make sure I addressed everything that had been raised. Oh, and I want to admit we were engaged by the Assembly member about this. And of course, we've been working with his office. He attended a presentation that we did at a national summit recently. So that's our involvement. I know the idea about the fingerprints and background checks, those costs being borne by the person requesting the determination. That's something that has been discussed, and I obviously this is the Assembly member's bill, but I think there's some more discussion to be had there. And the looking into the future part, one thing I want to say, there's 20 states that have done this already, nationally implemented these policies across the board.
30 seconds for me.
Thanks. And it's really about looking at how things are right now and getting a determination on now, and assuming that things don't change from now as far as your criminal history goes, then you should be fine, right? So it's fundamentally, you know, giving a green light to people who would not have any issues if nothing changes between, you know, the present when they apply, and then putting other people, right, on notice who potentially would have that issues, that licensure is not a certainty. Just the other point I want to make is,
please conclude.
Yeah, quickly. It's really about taking what's something that happens at the back end of the process and moving it to the front end. Ideally, for most applicants, if they apply for this determination, they get a green light. You don't have to go back and look again when an official application is filed. I apologize for going over.
Thank you for your public comment. Next up, we have Christina Hildebrand. Christina, you should be receiving the prompt on your end.
Hi, Christina Hildebrand, a voice for choice advocacy. Can you hear me?
We can. Please
Great.
go ahead.
I just wanted to comment. I didn't comment quickly enough on the last bill, but I just wanted to make a general comment, not pertaining to this specific bill, but just in general. Mr.
Sorry,
Bone,
but we're on a specific bill. So if your comment doesn't pertain to this bill, then
okay, then I'll relate it to this bill. Mr. Bone should know how I'm assuming he works with the legislature a lot. He should know how the legislature works. If they take something out of a bill, they've taken it out for a reason. Putting that back into a bill is extremely unlikely. So his recommendations that you do something like that, I would just ask him more questions about how the legislative process works in the future. Thank you.
Thank you for your public comment. At this time, there are no additional requests. Thank you.
okay, thanks. We'll bring it back to the board. Are there any additional comments or questions? All right, seeing none, Ms. Moriarty, if you could please call the roll.
Mr. Brooks?
Aye.
Dr. Gonadev? Dr. Hawkins?
Yes.
Dr. Hilzer?
Yes.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe?
Yes.
Dr. Tsai?
Yes.
Mr. Watkins?
Aye.
Ms. Lawson?
Yes. All right, that motion carries. Moving on to the next bill, is that 1733?
Indeed it is, Madam President. This bill modernizes open meeting laws to require the ongoing use of teleconference-based public meetings, including online meetings, similar to how we've been doing so during the first 2 years of the pandemic. In short, the bill requires state bodies to allow public access to their meetings via a teleconference option and allows members of the state body to participate remotely without disclosing their location should they choose. One key change as compared to the pandemic online-only meetings, which would be to require a state body to provide a physical location for the public to come if they wish to where they may observe and participate in the meeting. Those without access to the internet may avail themselves of that option if they so choose. The bill preserves public access and provides multiple benefits to the board and other state bodies while allowing the board to save costs and reduce staff time necessary to plan the logistics of complete total in-person meetings if the board chooses to do so. Accordingly, staff recommend a support position on AB 1733, and I'm happy to answer any questions.
Thank you, Mr. Bone. Questions or comments from members? Mr. Brooks.
Yeah, just a quick question. And so it says, the bill says we have to provide a facility for members who do not have access to the internet for all meetings. Is that what I'm hearing? So we're meeting down in Southern California. You would have to open up this room or some room in all jurisdictions of the state?
No, so if the board is going to meet and the meeting's going to be held remotely, right? So everybody's going to be in their office or their home or whatever, just like we've been doing mostly. Forget today, but we've been doing for the prior 2 years or so. Then the board would have to provide a physical location for the public to go to where they could engage in the meeting from that space. So there could be a computer and a speaker. One location, right? One location.
Yeah, just to clarify, so does that mean if I am participating remotely in Chico, that I've got to open up my living room for people to come hang out so they can be participating?
No, Doctor. So the members are allowed to participate remotely without disclosing their physical location. So like we did for these last 2 years, your location would not need to be disclosed. The bill does state if you have an individual that is over 18 years of age or older that is with you in that room, then you need to disclose that, not the name, but the nature of your relationship with that person. I think that's not public safety. That's just a protection measure to help ensure help avoid undue influence, I think.
I mean, I think the question for the board is whether or not we would like to be able to avail ourselves of what we got used to over the past 2 years, right? Which was being able to hold these meetings via teleconference and being able to WebEx in from our living rooms or from a location of our choice, or whether, we prefer circumstances now that the executive order has expired. Dr. Gnanadeb?
Yeah, this is actually a good bill because when one of the meetings, I had 30 people show up to my office. We did that on vaccine. We did remote bill, and including 10 kids. I had to find some fruit and some drinks and all that. It wasn't easy. So this helps, yeah, absolutely.
I guess from my personal perspective, it would be nice, we have quarterly meetings, right? So 4 a year. It would be nice to be able to do a couple of those perhaps via teleconference and then have a couple in person as well. I mean, I have been reminded over the past couple of days the value of having us all together in person, and even the ability to make perhaps better decisions because we're in person and we can see each other and we can have the benefit of even the body language, interaction. So it's certainly, I can tell you, it's easier to lead a meeting here in person than it is on Zoom. Not that that should be a determinant factor, but I think the flexibility of being able to do this, and also I do want to ensure that public is always going to have the opportunity to be able to WebEx into our meetings, because I think that's really important, especially because California is so large as a state, that I don't want to lose the ability for the public to be able to communicate with us from wherever they are and not have to bear the expense of traveling to Sacramento or to Southern California when we meet there. So, I mean, those are my comments.
One just brief point of clarification is that I think the law proposes to have multiple, two different options. You can do just a telephonic, so like a conference call, which I think is how the board has done some of that in the past, or through software like WebEx.
Right.
So
good. All right. Do we have staff's recommendation?
Support.
The support position. This doesn't require us, by the way, to do meetings.
It does require. I didn't mean to speak over you. It requires the telephonic option for the public. So we would have to continue on to either do, the phone or WebEx or something like that. So that we would be required to do that for public participation.
But it doesn't prohibit us from having in-person meetings. It gives us the option to have meetings via WebEx.
Yeah, and I believe even some board members could gather all together, and a subset of them could gather remotely.
Right.
So that's where the flexibility, comes in.
Which, by the way, appears to be what the legislature is doing these days. I think that sometimes some people are there in person, and then some people are on WebEx or Zoom or what have you.
I think to a degree, yeah.
Okay. Any other comments? Can I have a motion in support of staff's recommendation? Mr. Brooks is moving. Mr. Watkins is seconding. All right, we'll go to public comment now, please. Anyone in the room? All right, seeing none. Any on WebEx?
Anyone would like to make a public comment, please raise your hand or type something in the Q&A window. We'll call on you. Calling users, you can press *3 to raise your hand that way as well. Give me a few seconds to see if anyone queues up. This time I don't see any requests.
All right, thanks, Sean. We'll bring it back to the board, and I think that we're ready for a vote. Ms. Moriarty?
Mr. Watkins?
Aye.
Dr. Sy?
Aye.
Dr. Thorpe?
Aye.
Mr. Rue?
Yes.
Ms. Lubiano?
Yes.
Dr. Hilzer?
Yes.
Dr. Hawkins?
Yes.
Dr. Gonadev?
Yes.
Mr. Brooks?
Aye.
Ms. Lawson?
Yes. All right, that motion carries. We're moving on to the next bill. I think maybe 2055 is not moving forward, so we're going to skip that. We're going to do a brief update on 2060, or are we?
Yep.
Okay.
Here. Thank you. AB 2060, this is the legislation being sponsored by the board to change the composition of the board from a physician member majority to a public member majority, just exchanging one seat for the other. Go from 8-7 physician to 8-7 public. It would do so, again, converting that one position. The bill also allows the board to determine the composition of its disciplinary panels, except that no panel may have less than 4 members. Page 2 of the analysis discusses the opponent's arguments against the bill, which staff strongly disagree with. No action is specifically required, as the board is already the sponsor of this bill, and I'm happy to answer any questions that the members may have.
So this is not an action item, but are there any questions or comments from board members? All right, seeing none. Is this something, Ms. Webb, that we need to take public comment on if it's not an action item and we're just got an update?
That is the board's practice.
Okay, so the board's practice is to take public comments. So looking out in the hearing room, it doesn't look like there's any public commenters here, but Sean, if you could open up the line.
Anyone like to make a public comment on AB 2060, please raise your hand or type something in the Q&A window and we'll get you called on. Maybe a few more seconds to see if anyone queues up. This time I'm not seeing any requests.
All right, thanks, John. So we'll bring it back, and we're moving on to AB 2098.
Thank you. This bill establishes that the dissemination of misinformation and disinformation related to COVID-19 by a physician constitutes unprofessional conduct. This bill focuses on the spread of this type of information in the context of the physician-patient relationship. The analysis discusses the challenges that the board expects to face if implementing the bill as drafted, including a lack of clarity on whether the board must establish both a departure from the standard of care and that the information in question resulted in patient harm. Further, the definitions of mis and disinformation may prove challenging for the board to prove. As a result, staff suggests a support if amended position with amendments to strike subdivision B and to amend the definition of misinformation to connect it to violations of the standard of care. Happy to answer any questions, Madam President.
Thank you. Are there questions or comments from board members? Mr. Watkins?
Yeah, I just have a few questions and maybe a clarification. So this, I read the Nick Sawyer documents that was sent to us, and in that document, as my understanding is that, you know, in this bill, we work from the establishing a patient, a physician relationship that gives rise to what happens between the patient and the physician. And if there is misinformation or disinformation communicated between them, then it further states that we would then apply in our new amendment the standard of care. That's one scenario. The second scenario is that this bill does not cover is the scenario where that patient-physician relationship do not need to exist because the misinformation or disinformation is actually done on the airways and in social media. So the evidence is already there. The unprofessional conduct under Section 2234E says that misinformation is dishonest, so we could act upon that. So right now, in my understanding, without even this bill, we could act on misinformation and disinformation right now because it establishes that we have such a right? And I mean, I'm open to hearing the board's position on them. And my ask would be, in this computer window, that when we went into asking on the Section 2270, misinformation means false information that is contradicted by contemporary scientific consensus, contrary to the standard of care. And so we already have scientific consensus. Is it not then better to say scientific consensus to the extent where its dissemination constitutes not gross negligence, the stuff was removed, but unprofessional conduct? So it's the last part of it, the parts that we struck to add contrary to standard of care, which means we need an expert, whereas if we go to zeroing in on the unprofessional conduct, that we would be addressing it at its core. We're really taking it to the legal part of it, that we just have to establish unprofessional conduct, because standard of care is so fluid that it provides too many openings for not being, not really for public protection, in my opinion. So clarification is, first of all, in this bill, we only focus on the physician-patient relationship, which is okay, but we have another section that we don't need a law for, that already establishes unprofessional conduct is happening, and I think more prolific online and everywhere else. So if we were to act, we can act right now. I think we have the authority to act right now, but we can seek advice on that. And just that instead of using the standard of care, which require an expert, we could just say that to the extent where it is disseminating constitutes unprofessional conduct, then we are already in the section of the law that governs that.
I'll let some of my maybe colleagues speak to the part of your question about kind of current practice. And but what I can say with regard to social media statements, if I understood you correctly, Mr. Watkins, was that was contemplated in an earlier version of the bill, which was amended out by the legislature in the committee that approved the bill. I don't profess to be a constitutional law expert, but there was a pretty good discussion in that committee analysis that spoke to recent Supreme Court decisions and the various factors at play with regard to a state's authority to regulate the speech of one of their licensees. And I believe then that committee decided that the most appropriate means would be to limit the bill to the physician and patient relationship and to, then avoid some constitutional challenges.
Just a couple comments from me. I understand the rationale, and I appreciate that there are legal restraints, but the fact of the matter is this bill does not address what the actual problem is, right? It doesn't address the fact that we have California licensed physicians who have intentionally spread false and misleading claims about a wide variety of things, right, including COVID-19 vaccinations. They're advocating for the use of unproven, dangerous therapies that actually are harming California consumers, and they're stoking fear in communities not only in California but across the country. So this bill, maybe this bill's not the vehicle. Maybe there are risks, if we enforce our laws. But the fact of the matter is we have California licensed physicians causing great harm in our communities, and we have to figure out a way to address that. And again, maybe that's the medical board's jurisdiction. Maybe it's the Department of Justice. With fraud and other, BMP 17200 claims that they can advance. But look, we're going to have to figure out how to address this. And I know it's coming up in the context of this particular bill, but yeah. I make that point because I feel so strongly about it.
And thank you. I'm as passionate as you are, Madam President, on this misinformation and disinformation. The challenge is I don't think this bill is the right bill. Right now, from the medical board perspective, we're addressing standard of care. Once we try to go after physicians about, speech that, may or may not be protected, that's going to be counterproductive to our mission. And that's what I'm afraid of.
There was a document provided, I think a couple of times, last board meeting that addresses someone that actually addressed those constitutional issues that Nick Sawyer sent to, Dr. Sawyer sent to everybody. I just can't find it now because I was reading it and I don't know what I did with it last night. Here's the issue. Maybe I can get advice, because it's advice that I seek to address this issue, is do we have right now, outside of this bill, the law on our side to actually go and at least, it is unprofessional conduct if we hear somebody spreading disinformation on the internet or all over the place. Do we have the right, and maybe someone could write us a memo, maybe the AG's office, to actually pursue that, or at the very least, send out a letter from the board to say, hey, stop that. The very least, to send out one of those letters of advice. I think that in the absence of us not doing anything, this is just being exacerbated. And I'm speaking to myself because I was just in Africa, and I was dumbfounded to see how misinformation has spread in South Africa, where I'm from. And even though people, without getting into things, it was just astonishing. And since here in California, we are the standard bearers, I just feel a responsibility to uphold this side so that it perhaps can filter out to the rest of the world. It needs an example. And I don't say what I'm saying is, so my ask is just to ask for a legal position, a memo that the board can receive about, if we can, why aren't we? If we legally can. So that's my ask. As of the bill, I mean, I understand that patient-physician relationship, so I don't have any issues with that for that one context, but it's the other context that we may have power on right now.
So I'm just hearing a couple things. One is a broader outside the context of AB 2098. The board would appreciate having some confidential legal advice in the form of a memo that is distributed to the board members that speaks particularly to this, specifically to the issue about what we can do under our current laws. So I think that would be helpful. So we'll take that offline as a separate issue. It is something that together with our legal counsel, Dr. Hawkins and I have spent some time talking to them about as well. So we'll make sure that the board has that information as well, confidentially under attorney-client privilege, so that you can take a look at it. But with respect to AB 2098, I think that the staff's intent is to make sure that this bill doesn't make our jobs any more difficult, right, than it already is. I think that's the intent of staff's recommendations. And so, I mean, maybe we can refocus on that. I recognize I got us off track a little bit. Maybe we can refocus on that.
And just to add, the idea of the standard of care being connected to the misinformation definition that's a concept that recognizing Mr. Watkins' statements on that, but that's a concept that is familiar with the board. We deal with violations of the standard of care all the time, and our investigators and our our attorneys. So that was the idea there behind that staff suggestion, Mr. Watkins.
Clarifying question. Oh, I'm sorry.
You see, I wanted to explore, is there another way that we could do it outside of, that fluidity of standard of care? I know I'm asking a lot, and I'm asking outside of the box thinking, but it was originally written to the extent of it, and just something to explore. I'm just open to hearing if there's more creative ideas that puts us in a better legal position, because standard of care gets expert heavy, and then it's fluid. That's all I can say.
I'm happy to make a few comments on this. Part of what staff wants to do here is have a law that, if challenged, will be upheld. Otherwise, why are we doing this? So we want the law to be upheld. We also want to factor in that things are changing in this arena all the time. And so if we tie it to standard of care, if there's new treatments, new types of vaccinations that come online, that's factored in at that moment in time where the alleged violation occurred. So there's very specific and careful reasons why we're making the suggestions that we are, and that the board's role is not to monitor speech in every context, but tying it to the physician-patient relationship was something that we felt would protect this law if challenged, and the board's role in regulating its licensees. It is a complicated area, and there's a lot of moving parts to it. So we do need to be careful.
Dr. Gananadeb?
Yeah, this is a really tough issue because we do want actually people stop giving misinformation about treatments for COVID. This was the way it came on both vaccines and COVID treatments. But at the same time, you got to remember that medicine is not a stable thing. It constantly changes. What is today considered to be experimental or even voodoo becomes treatment of choice several years down the road. So this is not as simple as we thought when the bill first came in. We said, oh, thank goodness we can stop these guys hurting people. because people believe physicians, and they might follow those things. So we got to work with the author how that all those concerns are taken care of at the same time that the boards will have the authority to discipline doctors who are truly giving information which can hurt the patient. That's what we wanted. It's not just misinformation which can be detrimental to their health.
Yeah, I mean, not in my opinion, it's not just that they're giving information that is detrimental to the health, which there's no doubt that some of our licensees are doing exactly that, but they're also profiting off of it, right? Which I find particularly disturbing. And those are areas where I'm not sure the medical board is the right agency to target that sort of behavior. But to your point, Dr. Gnanadev, and I actually, Dr. Thorpe, you said it, we were talking I think during the panel meeting. I mean, a physician is one of the only, professional relationships where when a patient walks in the room, they immediately trust someone they may have just met that instant, right? They may have just met that person and they instantaneously trust them. They, allow an examination of themselves. They tell them a whole bunch of information about themselves that they might not tell to others because of that trust-based relationship. And that's why I think that it's so important that we address this issue, right? Because when patients across the country, across California, hear from our licensed physicians that you should take this dangerous and unproven therapy for COVID, for whatever ailment, they trust that. And we somehow have to be able to intervene and take steps to make sure that patients and consumers in California have access to factual, scientifically grounded information, recognizing that those standards change over time, recognizing that in California, our companies and our residents are often those who are developing and on the cutting edge of new therapies. But for the sake of us all, we have to figure out how to address weaponized misinformation and disinformation that is fraudulent and that is intentionally targeting, those who we are entrusted to protect, and not just, jeopardizing their health, but frankly stealing their money as well.
And I think we can get what I'm sensing the board members want, and that is, for example, if someone makes a comment on Twitter or Facebook or through a bullhorn, but no one responds to that in the context of a physician-patient relationship, then it's out there. But as soon as that person, in the context of this trusted relationship, spreads misinformation to that patient, whether that patient acts on that misinformation or not, or disinformation, that's where we want to address this and be able to get access to those records and investigate whether there's a violation that can be substantiated and whether discipline is warranted in that context.
I think this is a challenging, issue. I'm not quite sure if AB 2098 is the right vehicle or the right thing. I mean, we're talking about two different distinct subjects, right? We're talking about the person in the bullhorn or is out on Twitter in the public sphere. This goes back to the old, yelling fire in the theater. You actually can yell fire in the theater. That is not illegal. It becomes a issue if someone gets hurt as they're exiting out. The Constitution says nothing about yelling fire in the theater. If someone gets hurt because of your action, that's the issue, right? And so it's really difficult to find that nexus in the public forum, one. From a patient-physician relationship, to me, the base is all about, did my advice go outside the standard of care and cause harm to my patient? This is what we do every single day, right? So that has not changed. I'm not quite sure how this bill is adding any extra protection to that physician-patient relationship. And I don't know how we can monitor those physicians. You know, my passion is the same with President Lawson. They're getting paid for misinformation, and it is wrong. I don't know how we monitor, enforce public speech. And what I'm afraid of is someone has a lawsuit, comes to this board, and someone really gets harmed, and there's no severability clause, and all of a sudden, you know, that doctor walks off free and the patient is still harmed. So
I do want to clarify that the board does not have to prove harm. So I don't want to have anyone in the legislature to add that as a requirement. And that's something we're trying to address in this as well. We don't want to have to prove harm. We don't in other instances. We only want to focus on whether there's a breach of the standard of care.
And one thing to add, and it's reflected in the write-up here, but I neglected to reinforce it in my verbal comments, is that one of the additional amendments that we are seeking is to incorporate the language that was in Senate Bill 920, which was introduced earlier this year, which would grant the board enhanced medical record inspection authority. That's a previously approved position by this board, so I don't know that it's a controversial matter before, you know, the members here. But that might, perhaps to your point, Mr. Brooks, provide, if that language were to be included into this bill as well, might give us some additional tools in order to, you know, more effectively investigate and prosecute these types of cases.
Yeah, as I said, I'm gonna vote no on this bill until we get an analysis from our counsel, because I think this bill is, there's a lot, we need all the information we can before we make an informed decision. So, thank you.
Yes, excuse me, Dr. Thorpe.
Thank you. So I think that none of us want to have, we all want to oppose misinformation that is intentionally aiding our own pocketbook, intentionally, giving our, helping us make more money that we wouldn't have made otherwise. That I say we as a physician, and none of us want to have any colleague give information, intentionally give misinformation, so that you're intentionally giving information that you know is wrong and is not helpful. The problem is that there are people who, even in this environment of COVID-19, there are clinicians who believe that what they are advocating is good therapy, and is helpful therapy. And I think that's the real crux of the problem. Is yes, no one would disagree that we should not give misinformation that we know is wrong and that we know is and with intent to harm, or with intent to deceive, or with intent to distract our patient from health, from getting health. But you're always in this, as Dr. Ganandev pointed out, we have this challenge in medicine that medicine is always in evolution. It's always changing. And Dr. Ganandev and I have been practicing long enough to know that what we thought was good science when we began our practice a number of years ago, I won't go into how long ago that was, but when we began our practice a number of years ago, is not good practice now. And in fact, the whole pharmacy of medicine has changed in the last 40 years. the whole practice of surgery has dramatically changed in the last 4 years. So, there was a time when some of those people who were pioneers in those areas where we have changed for the better were looked at as outliers and not really weren't the standard of care specifically, weren't the standard of care. So I'm not advocating that we do anything different about this language, but I would just want to make a statement about being aware of the challenge of a clinician or a group of clinicians who are advocating for a position they really believe is helpful, but is not the standard of care. And it may be a leadership role, maybe in a research role, but we've got to be careful that we don't put ourselves in a place where we're so reacting to the current situation that we don't allow for innovation and improvement in medicine. That's all my only concern.
Dr. Thorpe, I agree with you that these issues aren't necessarily always black and white, and there are often gray areas, but there are also circumstances where our licensees currently are disseminating verifiably false information, right? And this isn't necessarily a standard of care. I mean, it's like use on the one extreme, you should ingest bleach to take care of COVID-19. Verifiably false information, right? And of course, there's everything in between, right? We have active California licensed physicians who are disseminating verifiably false information. Again, this is sort of outside the context of AB 2098, which I think the author's intent was to make clear to our licensees and to the public that dissemination of certain type of information is unprofessional conduct, giving us the ability to take action where we see it. We think, our staff thinks, that this bill can be improved to make clear right, what the standard of care is. And again, it sets aside some of these broader issues that I think we need to address. I think we need to have a conversation about how we address them, because it may not be through the Medical Practice Act, it may not be through our enforcement function necessarily, in terms of taking a disciplinary action. Frankly, sometimes it just takes too long there. But I think the intent of this bill is to just make clear to the public that we can take action under these set of circumstances, even if, frankly, we already have the authority under the Medical Practice Act to do so where there's a standard of care violation.
Yeah, a law that gets enacted that the board is not effectively able to enforce will lead to a lot of frustration for, I think, probably all the parties involved.
Right.
So that was the key consideration of the board.
Are there additional comments? I know that this is one where there is some public interest in commenting.
I just, I don't know, Aaron, if I missed, what was your staff recommendation on this bill?
So the staff recommendation is support if amended, and it's on the 4th page of the bill.
Okay.
One of the, so the first recommended amendment is to, include the enhanced record inspection authority, which the board has previously approved in our legislative proposals. We think that could go a long way in helping with some of these cases. And then the other changes are more technical in nature, striking subdivision B that would remove some of the ambiguity that we see in the law, in the proposed law, and then to change the definition of misinformation to align it with standard of care violations.
Do we want to move staff's recommendation before we take public comment?
Make a motion to approve staff recommendation. Support if amended.
Moved.
Second.
Great, thank you. All right, we looking in the room. Is there anyone in the room who would like to make public comment? All right, seeing none. Sean, if we could go to the WebEx, please.
Yes. Anyone who'd like to make public comment on this bill, please raise your hand and type something in the Q&A window for to get queued up for make public comment. First up, we have Christy Sepulveda-Burchett.
Burchett of Educate Advocate. Can you hear me?
Sorry, Christy, when you introduced yourself, it got cut off. Please start over.
Oh, I'm sorry. Hello, I'm Christy Sepulveda Burchett of Educate Advocate. Educate Advocate is a statewide grassroots nonprofit organization that serves families with children with exceptional needs. On behalf of the families we serve, I'm asking the medical board to withdraw their support and either be neutral or oppose AB 2098. The language is too broad. There's no standard of care or contemporary scientific consensus on COVID. What was recommended in early 2020 for care is no longer standard of care for treatment such as ventilators. Families like ours that may be medically fragile need a range of options for care and treatment, and doctors who offer such should not be labeled as purveyors of misinformation. This bill has unconstitutional restrictions on free speech. Further, this bill's passage will cause good physicians, especially those who serve our families, to leave California. I ask you to support the good work of our physicians in our state and not side against them. Again, I ask this body to withdraw your support of AB 2098 and move to a neutral or opposed position. Thank you.
Thank you for your public comment. Up next here, we have Christina Hildebrand. Give me a minute to send you the request. Oh, there, he's in this list here. Christina, you should be seeing that request on your end.
Hi, Christina Hildebrand. Can you hear me?
We can. Please go ahead.
Great, thank you. Christina Hildebrand from A Voice for Choice Advocacy. We are one of the main opposition on this bill. Oh, there was a lot discussed, and I'm thankful for all the board members for acknowledging that standard of care is fluid and that standard of care today is not standard of care tomorrow, and that we cannot cut out innovation. And that innovation is not standard of care today. This is something I've been saying to the medical board for years. So thank you for acknowledging that. It was wonderful to hear our doctors on the panel actually say that. So on this bill specifically, I ask you to withdraw your support and move to a neutral or opposed position. There was a lot said. It is unconstitutional. You cannot stop or you cannot prevent physicians, and this isn't even in the bill, but it used to be in the bill, from putting things out on social media, from using a bullhorn and saying things. That's our First Amendment right. We live in the United States. We have that right. When we get to actual patient care, this bill specifically says standard of care and scientific consensus. There isn't standard of care or scientific consensus on COVID. If we were talking cancer, it would be a different matter. But on COVID, we are still in an evolving process because COVID is evolving and the treatments and the vaccines are evolving. I wanted to bring up the first proposal of an amendment, which says that the board would be, it's basically SB 920, which you put forward. SB 920 would have allowed medical records to be looked at in the interim without a subpoena. That bill, you cannot request that as amendment. That bill was paused, halted, withdrawn because organizations like the ACLU was against it because it would have been unconstitutional and it would go against HIPAA violations. So I ask this board that you do not request that amendment, or maybe you do, then this bill would die anyway because that bill already died. I think we need to look at what this is looking at, misinformation. If a doctor right now, if this bill passed, if a doctor said to a parent, I don't think your 5 to 11-year-old needs a booster because they already had COVID, that would be considered misinformation. So, because it goes against CDPH, it goes against standard of care, it goes against what the CDC is recommending. But that's not something that should be taken as misinformation or disinformation. I think you need to look at the number of complaints that would come
30
in.
seconds remaining.
And even number one, you don't need this bill. You already have the jurisdiction to do it. It's not necessary. Number two, you need to look at the financial impact. We've been hearing all day yesterday and today that, the board is strapped for money. This is going to put in a huge number of additional complaints on little things like social media posts that you don't have the money to go after. We need you focused on the doctors that are doing true harm to patients and not going after these little bits and pieces that are going to be coming in as complaints. So I really ask you strongly to withdraw your support and move to a neutral or an opposed position. Thank you.
Thank you for your public comment. Next up, we have Nick Sawyer. Nick, you should be receiving a request on your end to open your mic.
Can you hear me?
We can, Nick. Please go ahead.
Okay. Fantastic. So I just want to make a few statements here. May I ask a question to start? How many members of the board have watched the video of Christina Lawson that was made about Christina Lawson? Can we have a show of hands of the board who actually watched that video?
Dr. Sawyer, just go ahead and make your public comment.
Okay.
You've got 3 minutes.
So the public comment that I want to make was, first of all, the Federation of State Medical Boards started this by saying that physicians who spread COVID-19 vaccine disinformation or misinformation are liable for having their licenses revoked. And I think that was very smart of them to do, because when it comes to the type of disinformation that is harming the greatest number of people, and the people that I see coming into my emergency department who are unvaccinated and otherwise should be, are the people who are receiving this disinformation about the COVID-19 vaccines. And so while I hear other people talking about how this is going to cause a problem for academic debate, what I want to remind you is that when it comes to the COVID-19 vaccines, there is no evidence that the COVID-19 vaccines have killed more people than COVID. There is no evidence that the COVID-19 vaccines inject nanoparticles into your body that the government is going to use to control you. And so, yes, maybe this bill will help, maybe it won't. But the California Medical Board has the responsibility to protect the public from this type of rhetoric, because we already have over 200,000 people estimated dead because of this misinformation, and I continue to see it. And it's really harming everybody on the front lines who are taking care of these patients, and it's harming the people that you have been appointed to protect. I thank you for your time.
Thank you for your public comment. Up next, we have Dr. Hannah Ree.
Yes, thank you. So this is Dr. Ree calling on behalf of Black Patients Matter. So certainly this is an important topic. There's a great deal of misinformation out there, but what I haven't heard from any of the comments was the fact that for minority groups, especially within the African American community, there are home remedies which are beneficial to alleviating some of the signs and symptoms associated with COVID. And as we know, the mortality rate amongst Black patients is significantly higher. And we attribute that to racism within medicine. The fact that most California physicians have never treated, either by choice, voluntarily, or by population size, have never treated a Black patient, let alone touched melaninated skin. So these remedies could possibly be considered misinformation, disinformation, but not within the Black community. So we would discourage the support of this bill because it is, we believe, race-based, in that it addresses the average white patient in the state of California. Thank you.
Thank you for your public comment. Up next, we have Dennis Cuevas Romero. Yes, you should be seeing that prompt on your end.
Yes, thank you very much. Dennis Cuevas Romero with the California Medical Association. CMA is a co-sponsor of the bill, and we support the author's intent in providing clear statutory framework for the medical board to pursue discipline against physicians that flagrantly disregard their ethical and professional responsibilities to practice medicine in the best interest of patients. CMA is interested in trying to thread the needle to get at what Board President Lawson talks about physicians that are flagrantly and clearly disseminating information publicly on COVID misinformation, on COVID. It is challenging, and that was laid out pretty clearly in the Assembly Business and Professions committee analysis. It's still CMA's intent to try to thread that needle, although it will be challenging. We hope to work with the board and the legislature on doing that moving forward. We appreciate the board's support if amended position and look forward to working with the board and the legislature to address the language and making it more workable for the board. Thank you.
Thank you for your public comment. Up next here we have Virginia. Virginia, you should be receiving that request to unmute on your end.
Hello, interested to go after the CMA, who has more power than the medical board. I appreciate the doctors saying how fluid it is, because once again, hand washing in the 1800s was not viewed as standard of care. It took a century for hand washing to become standard of care. And the person who introduced it died of sepsis. Zantac, which was standard of care, was removed from the market. So it's hard to know. Like, it's fluid. It changes moment to moment. While I'm fully vaccinated, I am still concerned about long-term impacts of this vaccination. And it was days after I got vaccinated that I had the nerve pain that landed me in the hospital. And for standard of care, there's still tons and tons of medical research that's in PubMed that has not been introduced into medicine. I heard it took like 17 years for that to be introduced into medicine. So like the brain-gut axis affecting mental health is still not well used, even though it was in research for like 10 years. So it's very fluid, and it's very hard to have standard of care when there's a lack of dissemination of research. And I do think it's very important for doctors not to totally disregard common sense and offer bleach, which I am not sure if they do. I know Trump did, but I don't think doctors do. But I think a lot more research needs to be done about the effects of these vaccines and risk versus benefits. And some populations can't take these vaccines, and that needs to be acknowledged that the risk versus benefit is not safe for that population. That's it. Thank you.
Thank you for your public comment. Up next here we have Laura Powell. Laura, you should be receiving a prompt on your end. Nope, just lost Laura Powell. Next up here we have Susan Lauren. Give me a second. Let me try Laura here again. Hold on. There you go, Laura. Looks like you got that
Laura
prompt.
Powell with Californians for Good Governance. We oppose AB 2098 because it violates the First Amendment rights of doctors. The constitutional problem can't be remedied by tweaking the language of the bill because it's baked into the DNA of the bill. The purpose of AB 2098 is to restrict speech based on its content, and our Constitution simply does not allow such a broad infringement on speech, even if the speech is considered false, and even if the intent of the law is compelling. The mere potential that the law could be applied in a way that chills speech renders it unconstitutional on its face before it's even enforced. This bill can't be salvaged because if you were to strip away every unconstitutional element, what you would be left with would duplicate existing law. So what would the bill actually accomplish? It would discourage conscientious doctors from expressing themselves freely. To quote the U.S. Supreme Court, regulating the content of professional speech poses the inherent risk that the government seeks not to advance a legitimate regulatory goal, but to suppress unpopular ideas or information. Doctors help patients make deeply personal decisions, and their candor is crucial. Throughout history, governments have manipulated the content of doctor-patient discourse to increase state power and suppress minorities. Professionals might have a host of good faith disagreements, both with each other and with the government on many topics in their respective fields. The best test of truth is the power of the thought to get itself accepted in the competition of the market. And the people lose when the government is the one deciding which ideals should prevail. And from another case, the remedy for speech that is false is speech that is true. This is the ordinary course in a free society. The response to the unreasoned is the rational, to the uninformed, the enlightened, to the straight out lie, the simple truth. So because AB 2098 is unlikely to withstand a constitutional challenge on First Amendment grounds, and because the damage it would cause to our core principles is not worth any potential benefit to the public health discourse, I urge the board to withdraw
30
its
seconds,
support
right?
for this bill. Thank you.
Thank you for your public comment. Up next here we have Susan Lauren. Susan, you should be getting that request on your end.
Hi. I didn't listen to the discussion. I was offline, and someone called and said they're talking about misinformation and disinformation, so I'll just say in 1 minute, if we're going to focus on those things, then we need to focus on them for everything, not just what someone wants to pick out as their pet project. We know the plastic surgeons flagrantly disregard the truth, and they are giving misinformation and disinformation out as they have been doing for decades. And it's had really significant long-term health for the people that get it done, and it affects all their families. You know, there's a woman that calls occasionally, Susan Liu, who talks about her mother who was killed by Leslie Moglen way back in 1996. Nothing has changed. So I want this to be included with misinformation and disinformation, but not to the point where people don't have free speech. I do believe in free speech. Thank you.
Thank you for your public comment. Up next we have Renee.
But aside from that, I'm also
Renee, could you start over? Your introduction got cut off there a little bit.
You got it. Sorry, my name is Renee Rogers, and I'm on the board of California Parents United. But aside from that, I'm also a parent and a member of the public that you all serve. And I want to remind you that these bills affect the public as much as the associations have a say. At the end of the day, you're there to protect the public. So let me explain to you what these kind of bills have effect on the public. What this bill will do is essentially limit doctors from giving the right standard of care, even if it's a small percentage that needs something that is outside the standard of care. These doctors are afraid. They are limited by their insurance companies. I have personally seen the letters threatened by the licensing boards. Should they speak against writing the medical exemptions outside of what has been considered law as standard of care? We have attorneys threatening them, saying, if you continue with the treatment method, you are threatened with liability. Stop doing it. I also want to remind the doctor who spoke, and although I have sympathy for the cases that he's treated, I want to tell you guys a story about a young girl in the Bay Area. Her name is Mila. You can find her on YouTube. She went to a doctor she trusted. Her college in Walnut Creek, DVC, required her. She was a 16-year-old who graduated early. She went to go be a surgeon. She went to college. Her college required her, in order to take her labs, to get an unapproved vaccine that was the standard of care for our country. A 16-year-old walked in, got her vaccine, and within 5 minutes was taken by ambulance. And after seeing 7 specialists, who, by the way, mind you, prior to this, was training for triathlons. She was a dancer, and now is wheelchair bound with seizures. And let me remind you, you know what her standard of care was? Psychosomatic symptoms caused by lockdown. The standard of care. And we have one doctor that is even willing to treat her because of the limits of what the medical boards have put on our doctors. And continuing to push this You are lowering, you are reducing the standard of care for the public that you all serve, and continuing to limit doctors and doing the research.
30 seconds remaining.
And doing the research and finding what is really helping these patients. If you have not seen what this injury has done on such a severe level, and the consensus in the community is they're psychosomatic and they have no treatment available to figure out how to fix these, limiting their speech and their way to practice medicine is going to completely eradicate the ability to get to the end solution. So I urge you guys you need to not back up this bill. We are nowhere in this place or ready for this.
Thank you for your public comment. This time I don't see any additional requests in queue.
All right, we'll bring it back to the board. Any further comments or questions before we take a vote? All right, I would just make a sorry, Dr. Ganandev.
Yeah, just want to comment on that. The newer treatments, even if they are not standard yet, but when we go through the process, there are experts on both sides. There are experts who can prove that this is a upcoming treatment which is not below the standard. So that is the concern some of us have, but the way we discipline doctors prevents that more on 99% of the time, because if we find a right expert who can justify that treatment the doctor provided, which is not in the medical literature standard yet, because medical literature continuously changes. So that protection is there. I just wanted to point out that it doesn't prevent people from taking on the newer treatments.
And just before we proceed to the vote, I guess a concluding comment that, of course, I support the goals and sort of the objective of AB 2098, but also from my perspective, there really is no better use of our collective time than making sure that the public and our consumers in California have access to factual, scientifically grounded information. That is, I believe, the objective of this bill. I think it gets to, the heart of our mission, and I do think it's our responsibility to counter disinformation and misinformation that is in the public domain, especially as it medical misinformation and disinformation, and I'll continue to work to advance that. So with that, Ms. Moriarty, please call the roll.
Yes.
Dr. Hawkins?
Yes.
Dr. Gonadev?
Aye.
Mr. Brooks?
Abstain.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe?
Yes.
Dr. Tsai?
Yes.
Mr. Watkins?
Yes.
Ms. Lawson?
Yes. Thank you. We're moving on to the next bill.
2178.
Sounds good.
This bill is a follow-up to prior legislation that established a definition of academic medical centers, or AMC, that authorizes those facilities to sponsor physicians seeking a special faculty permit. The analysis recounts the history of prior legislation in this area from 2020 and 2021. AB 2178 proposes technical changes to some of the definitions of an AMC to align them with current terms and the training experiences offered by those facilities. These proposed changes are detailed in the analysis and are not expected to substantively change the requirements to qualify as an AMC. Therefore, staff have a support recommended position, and I'm happy to answer any questions.
Dr. Ganandev.
Thank you, Aaron. I spoke to Mr. Bone before. In the Bill 806/2021, after we supported and recommended, they added an additional language. Apparently, it was by Senator Pan. The requirement that AMCs be accredited by Western Association of Schools and Colleges and ACGME. The WASC comes into play only if there is a school or a college attached, actually owned by that institution. I looked at the only one which had that was Cedars, because they have a nursing school. But places like City of Hope, Scripps, there are multiple institutions who can take up to the academic AMC level. Remember that we approved only one position for all the AMCs combined, which is already in the law. So I would rather have the premier hospitals be able to get to be the AMC level without that requirement that you need WASC accreditation. I mean, like my hospital is different because we have a medical school, that's why it's WASC accredited. Any school you have, you are WASC accredited, that's what is required. But if you're just a healthcare institution without going into colleges, not the residency programs, and you need to have ACGME, otherwise you can't have residents. So that's why I think maybe it was a mistake, but I would recommend to really point out at least to Dr. Pan and anybody else, we need to point out that that doesn't add any value to be an academic medical center. All the others do, and this is a cleanup bill for what was already approved.
Yeah, correct.
Additional comments or questions? So, Dr. Ganadev, is there something additional that needs to be incorporated?
Yeah, this is just like the nurse practitioner bill. This is a cleanup bill.
Right.
So my recommendation will be to remove WASC accreditation and leave the ACGME accreditation, and everything else I think is what we recommended.
Okay, and currently staff's recommended position is support, and so it would be a supportive amended position, or is that just a recommendation?
Well, I think that's the question for Dr. Ganadev. Is that a motion from him, or just a recommendation to staff to have a conversation, with the interested organizations in Senator Pan's office? Because you're right, the WASC accreditation issue, I believe, originated from the legislature. I don't know that came from Cedars necessarily. So I'm happy to have those offline conversations to clarify and, can report back to the members.
Rather than make a supportive amended, that may be a better option, because I know Dr. Pan can look into very carefully, because it doesn't affect anybody else. All the medical school hospitals are WASC accredited already, because medical schools are WASC accredited. All the UC system, CalMed, which I was part of, and USC, and all the schools are. But if you don't have a school of any kind, a nursing school or a PA school, then you are not, there is no reason for anybody to go for WASC accreditation. And Cedars has a nursing school, that's why it doesn't affect them. Whether you keep it or leave it or remove it, it doesn't affect Cedars, but it will affect, because our goal when we first started working on this, when Cedars brought it to us, this board, was to get some premier institutions in the state to be eligible to be AMCs. And I gave you examples. City of Hope is one, Scripps is one. There are multiple. So this is what we would rather have, I would rather have, rather than just one institution only.
And I do recall, Doctor, that was the board's sentiment in 2020 to not make this exclusive to one particular organization. So I'm happy to have those conversations with the right folks. And then in addition, this could be the sort of thing that after we kind of do a little bit more work, this could be a sunset issue that we could seek to be addressed in sunset if necessary next year.
Okay.
Dr. Sai.
I have a point of clarification. Does AMC, the acronym Academic Medical Center, only appear in this bill, or elsewhere in the Medical Practice Act, does AMC appear in other sections?
To my knowledge, it's limited to the Medical Practice Act, and it was added in 2020 because at the time you could only put forward a special faculty permit applicant if you were a medical school. And so the intent of CEDARS, who was the sponsor of the bill, and they may have a representative to add some comment during the public comment time, but CEDARS' goal was to seek the law to be changed so that way they could put forward their own sponsor their own candidates.
Yeah, we agreed with that because they're a large institution, they do research and they have residency programs. What we wanted to do is make sure that similar other institutions are eligible and we won't put too many restrictions on them.
Agreed.
Additional comments or questions? All right, so is that a motion to support staff's recommendation?
So moved with Mr. Bone having conversation on the WASC accreditation. Thank you.
And I'd be happy to circle back with you offline.
Second.
Great, thank you. All right, we'll move to public comment. I don't see any public commenters in the room. Sean, could you please go to the WebEx?
Yes, if anyone would like to make a public comment for AB 2178, please raise your hand or type something in the Q&A box and we can get you called upon. Give you a few minutes or a few seconds here to queue up. This time I'm not seeing any requests.
All right, we'll bring it back to the board. Ms. Moriarty, if you could please the roll call vote.
Mr. Brooks?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Hilzer?
Yes.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe? Dr. Sy?
Yes.
Mr. Watkins? Ms. Lawson?
Yes. All right, that motion carries. So we are moving on to
home stretch, almost done.
To
2626.
Great, thank you.
This bill is intended to prohibit this board and other licensing boards, as defined, from disciplining a licensee who was sanctioned by another state for performing an abortion that would be lawful under California law if performed in this state. This bill is not expected to change board action because although we have authority to discipline our licensees who are disciplined by another state, it is our practice to only do so when that out-of-state conduct violates California law. In the analysis, since the analysis was released, the bill was amended to include an urgency clause, which means that it would take effect immediately upon signature of the governor rather than January 1. As this bill reaffirms existing practice, staff recommend a support position. I'm happy to answer any questions, Madam President.
So moved.
Thank you. All right.
Second.
Thank you. Any additional comments before we open this up for public comment?
Is that so moved with the staff recommendation? Thank you.
All right, let's open up the line for public comment. Sean, please.
Anyone like to make a public comment on AB 2626, please raise your hand or type something in the Q&A box and we'll get you queued up. Give everyone a few more seconds here. This time I'm not seeing any requests.
All right, we will bring it back to the board. If there's no further comment or questions, Ms. Moriarty, if you could please call the roll.
Mr. Watkins?
Aye.
Dr. Sy?
Yes.
Dr. Thorpe? Mr. Rue?
Yes.
Ms. Lubiano?
Yes.
Dr. Hilzer?
Yes.
Dr. Hawkins?
Yes.
Dr. Gonadev? Mr. Brooks?
Aye.
Ms. Lawson?
Yes. All right, moving right along. We have one left. One of these is
our final bill. Oh.
Yeah, I think it's 1440.
1440. Right? Yeah, we were skipping over 1365.
Right, because that was held, not moving forward.
Correct.
Thank you.
SB 1440 makes clarifying changes to one section of the Midwifery Practice Act that was added to the law through the board's sunset bill last year. This newly added section provides criteria for the board to follow when reviewing quality of care complaints that involved a licensed midwife or LM. The section is very similar to the section for quality of care complaints against physicians, but is missing the language related to forwarding complaints to a field investigation or authorizing emergency action. The proposed changes to the law conform this section to the section related to similar physician complaints. Therefore, staff recommend a support position, and I'm happy to answer any questions.
Questions or comments? Have a motion in support of staff's recommendation?
So moved.
Dr. Hilzer? We have a second?
Second.
Thank you, Dr. Hawkins. All right, we'll move to public comment. Is there any public comment in the room? Seeing none, let's go to the WebEx.
Anyone like to make a public comment? Please raise your hand using the WebEx feature or type something in the Q&A box. Give everyone a few seconds to queue up. This time I'm not seeing any requests.
All right, we'll bring it back to the board. Is there any further comment or discussion? All right, seeing none, Ms. Moriarty, if you could please call the roll.
Mr. Brooks?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Hilzer?
Yes.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe?
Yes.
Dr. Tsai?
Yes.
Mr. Watkins?
Aye.
Ms. Lawson?
Yes. And that motion carries as well. I think we are...
Sadly, I'm out of bills, Madam President.
Sadly. Well, thank you for all of your hard work. We appreciate it.
Thank you, members.
We will move on to our next item, which is item 14B, 2022 regulatory actions. First up is was intended to be a discussion and possible action on proposed regulations for the Physician and Surgeon Health and Wellness Program. Unfortunately, materials weren't made available until just this morning, so we're going to postpone this item to our August meeting to give the board members and members of the public time to fully digest all these materials rather than, we thought about maybe we'd run through them in painstaking detail, but I think it's probably more prudent for us to take that up at our next meeting in August. So we will do that, and I guess lucky for staff, everything's already prepared for that, so you don't have to prepare anything additional. So we will move on to agenda item B2.
That's right.
All right, and Ms. Webb.
Members, please turn to your materials under 14B. And you may recall that in February 2022, at the board meeting, we discussed these notice to consumer regulations. These regulations address the notice that individuals must provide to their patients and clients to advise them that they are licensed or registered by the Medical Board of California, that their license or registration can be checked through the board, and that complaints can be filed with the board, and contact information on how to do that. The proposed regulations went through the 45-day comment period, and the board received comments from the California Hospital Association and the California Medical Association asking for certain modifications to the language, which the board accepted. The modifications include clarification that a quick response or QR code will be included on the notice template, which will lead consumers to the board's notice to consumer webpage. A translated notice will need to be provided in a language understood by the patient or patient's representative, but only to the extent that the board has provided for the translation. The board will translate the notices into the 12 most common non-English languages that are spoken in California per the California Census 2020 language and Communication Access Plan, which was prepared by the California Complete Count. And that requirement to provide the translations was included in the regulations. Additionally, the board clarified that the notice and acknowledgement of receipt and understanding may be provided and maintained in an electronic format. If the board approves the modified language, it will be sent out for a 15-day comment period. Therefore, I am asking for, it's a detailed motion, so bear with me, but a motion to approve the modified text to amend Title 16, California Code of Regulations, Section 1355.4 and 1379.58, and to add Sections 1378.5 and 1379.4. Direct staff to provide notice of a 15-day public comment period on the modified text. And if no substantive adverse comments are received during the 15-day public comment period, authorize staff to finalize the rulemaking file and submit it to the Office of Administrative Law, including the authority to adopt the modified text and make any technical, non-substantive changes without returning to the board. May I have such a motion?
So moved.
Moved by Dr. Hawkins, second by Mr. Watkins. Is there discussion, comments?
I have a question, and that's in each of these texts. There's a statement that, and it's usually, I think it's under, well, it varies a little bit in each one, but it's the third statement basically where it says, including the notice in a language understood by the patient or patient representative in a statement on letterhead, patient instructions, or other document given to a patient or the patient representative where the notice is placed immediately above the signature line, et cetera. So my question is, does that mean every time that you give, for like, you know, every time we see a patient in the clinic, we give them patient instructions, or we give them a after visit summary? Does that mean that every single time we do that, that we are then supposed to give this notice in connection to that after visit summary? Or any time you give a patient any kind of information at all? It just seems incredibly burdensome.
No, the idea was to give providers multiple options for how to comply. There's already a notice requirement. So physicians either need to post a sign or provide notice in some other manner, in a separate sheet or in instructions. So that's already a requirement for physicians.
Yeah. So if you post it in your waiting room or whatever, then you don't need to do this. Is that correct?
That's right. The exception, though, is if you have someone that doesn't understand the language and you're aware of that, you need to provide the notice in a language understood by the patient or the patient's representative.
Okay.
And so these regulations extend this out to the board's other licensees and registrants, I'm sorry, and just make some modifications to what the notice contains and how, and providing for the need to provide translated documents, which, you know, physicians, there's already requirements in place to make sure that patients understand the communications.
Thank you.
Dr. Gnanadas?
So, Kerry, most doctors' offices post in English and Spanish. That's pretty common. So the other language is the one which concerns me. How, so medical board is going to provide that to the doctors, the 10 other languages, which probably I don't even know which are the 10 other most common languages.
Well, yeah.
So.
Yes, so we're going to pay for the translation for that for all the licensees and the registrants, because there's 4 different notices here that are required in these regulations. And so the board will provide that, put it on the website so that it's accessible to the licensees and registrants, and we'll be doing outreach so that people know that this is coming well.
So they may have to hand over to them because you don't have space to put 12 plaques there. You got the wall space is not there in a small doctor's office. It makes no sense.
Right.
Okay.
This does ask something of providers to make sure that their patients know that this is the regulatory body over their license or registry.
Yeah, you mentioned that is a state law already, but usually in 2 languages, English and Spanish. That's what we're doing.
Dr. Thorpe?
Just a point of clarification. So the one option was to post it in your office with a QR code available so that with a device you could access that and select the language you want or you need on that. Is that? And then if that's not available, or if the patient or their representative isn't able to do that, then the practice will access the medical board website and print off from the medical board website the appropriate language instructions?
Or provide it electronically.
So I'm just trying to understand how this would work practically, because there is I do have a fear that this is going to be a significant burden. But so if you have a portal, a patient portal, where patients can access their information, it could be posted there one time for everyone to be able to access there.
Yes.
I mean, I realize you don't know exactly how it all works, but I'm just trying to imagine how it's going to, I understand the importance of giving the information in language that people can understand. I totally get that, and I am very in favor of that. I am just concerned that sometimes our good intentions are become very burdensome, and so I just want to make sure we're giving a relatively straightforward process for practices, especially private or solo practices where they don't have a large hospital institution that can post it in a prominent place, to be able to get access to this information in a reasonably painless way and provide it to their patients in a painless way. That's all my only concern. I guess my question is, if you can provide it electronically through the patient portal or some other email or whatever, or you can have a QR code that you can scan, or you can print it off from the medical board website, assuming that's working, then those would be acceptable ways of doing it.
Yeah, I mean, the QR code, if you only have a sign posted in English, it will have a QR code on it, but this regulation doesn't intend that that's all you have to do, because if someone can't read the sign, they won't know that this is applicable to them to scan the QR code. So, I mean, and you can correct me if I'm wrong, Dr. Thorpe, but presumably you would know if a person or the representative doesn't understand English. So the first iteration of this required it to be provided in the person's primary language. Our commenters made a good point that if it's in a language that they understand, that is appropriate and that's less burdensome. And so that change was accepted. But this is important information for patients to have, and so it does somehow have to be communicated to them in one of 3 ways.
So,
posting provided in materials, and posting in a place visible to patients could be in an electronic manner. So there's not a restriction on that.
So we dealt with this issue at Board of Pharmacy, and same issues. Every office building pharmacy was built differently, and we had posters that were already required to get posted. And so what they ended up doing is going down and buying a 99-cent iPad, velcroed it to the wall, and it was just a loop on an iPad, and it took up about this much space, and it met the regulation. So that was their solution to the problem.
Yeah, I mean, that could run through all of the required languages.
Yeah, it was just constantly rotated.
So Dr. Thorpe asked a very good one, pointed out about the QR. Is it possible for the medical board, when we do the 10 other languages, to have a QR code, and then we can put them all in one frame? In Arabic, it's written in Arabic with a QR code. In Iranian, we can, in Persian, you can do the same, or Hindi, you can do the same. So I'm just curious, how can we make it easier, more electronic, rather than passing the paper out each time or putting 12 different things on the wall?
I'm having a hard time visualizing how you want to change the QR code. Like,
when you scan it, it comes, if it is below it, it's written Hindi, it will pop up in Hindi. That's what I'm looking at. If it is in Persian, it's same. If it is Arabic, it's same, rather than in English.
So you want the language to be beside the 12 QR codes? I mean, it won't fit on the sign with the font that is in there, so it would be, the sign would be reduced to a smaller font.
Can I make a suggestion that this sounds to me like an implementation rather than what's actually in this regulation, right? The regulation requires something specific, but I do feel like our medical board staff can have 12 different templates with QR codes with other languages, right? And make it really simple and straightforward for providers to go on their website and download whatever they need. So I don't want us to make this unnecessarily complicated from an implementation standpoint.
I think from my understanding is that there's 10 different languages with one QR code, because that QR code directs it to the medical board. The medical board website is not in 10 languages. It's only in English. So for the person who speaks Spanish or Chinese or Korean, they would scan the QR code after reading it in their language to say, okay, I'm going to go on the medical board site. But once they get there, it's only in English. So that's why with you having 10 different QR codes, it doesn't make any sense, because it's directing it to one web page. I think that's where the confusion is, because I think if you have web pages in 10 different languages, you need separate QR code for each one of those web pages. But if it's just going to the one web page, you only need one QR code.
Right. I mean, I think that people have translation services for websites. So, but staff had recommended against including a QR code because of the belief that it wouldn't prompt someone to scan it if they didn't understand what the sign was saying to begin with.
Madam Chair. Madam Chair, as you stated, this is an implementation problem. Can we just direct staff to have multiple versions, of it, whether it's have a QR version, have a straight 10 different language version, so that doctors could pick and download that's legally usable. Because quite frankly, I think what Mr. Brooks said is probably the most feasible. I know there's a cost factor with iPads because, and I don't want to go down this road, because QR codes, if you're a senior, if you're elderly and don't have a phone, then you don't even know what a QR code is or how to even access it. So it just goes down a rabbit hole. So if staff could have multiple versions, have a QR code option, have a language function, and different versions of it.
I mean, I think, Ms. Webb, correct me if I'm wrong, but isn't that what the regulation says, right?
Yes, we are going to prepare every notice for every licensee and registrant in the 12 most common language in addition to English that are spoken in California pursuant to this particular study.
Right.
And those are all going to be available on the board's website.
Right. So to me, this is an issue of how do we communicate with our licensees about what's required and how do we just make it simple and user-friendly. We can do that through the board's newsletter. We can do that through other special communications and the like. So I think but I don't sense that there's a lack of support from the board for the regulation itself.
Well, I do have this. I'm looking at a small practice, not mine. Mine is in a large hospital. It doesn't affect me. But in a small practice, it is a tough issue. So we got to make it, implementation is the problem. We got to make it as easy for them to really get, to comply with the regulation or the law. So we can't just say it's on our website, and they have to go there, print it in 12 different stacks of paper, and give it each time we give, or have it 12 different languages on the wall.
But Dr. Gananadev, in practicality, you know if your patient can't communicate with you in English, right?
Yes, I do.
Somebody knows that.
Yeah.
Yeah. I mean, so, and I don't think it's going to be, I mean, I'm sure there are practices where there will be 12 different languages spoken, and I would assume that the physician and the physician staff there knows that, you know, the population being served there speaks those 12 different languages, right? Because you're interacting with those patients in a way that you would know that they are not speaking English, for example. So I guess this just seems to me that if your practice is such that you're serving multiple language speakers, you would know to go download the form, right? And the medical board's going to provide all those forms in a very easy way for people to download.
Make a comment, Christina. I have a staff. Our staff will handle it. It's not that complicated. There aren't that many different languages in the office. Most there's 4, and it's not going to be a problem, I don't think.
All right. If there's support for the regulation, I'd like us to have do we have a motion already?
Yes.
I can't remember who moved it, and okay, Hawkins and someone else. We have not gone to public comment, unless I've lost my ability to track what's going on in this meeting.
We have not yet.
All right. I don't see any public commenters rushing up to the podium in the room. If we could go to the WebEx, please, Sean.
If anyone would like to make a public comment, please raise your hand or type something in the Q&A window. Up first here we have Eric Anderson. Eric, you should be receiving that prompt.
Richard, you and the CMA always make doctors sound so lazy, always talking about the burdens they have to deal with and making sure patients are safe. The CMA make doctors sound cheap for not wanting to raise license fees in order to make sure this board can afford to function. And you know that few to no doctors will be dealing with this aspect of office work themselves. They'll be having their receptionists do it. You should see the walls in a lot of union workplaces, including backstage on Broadway shows where laws, rules, and regulations cover the walls like wallpaper with huge posters full of information available to their employees. So don't talk about covering your lobby walls with these things. I mean, this is what we do to make sure people are safe. The medical board could very simply make a page on their website that scrolls through the information, and a doctor can just keep a cheap laptop in their waiting room directed to that website that scrolls through the information 24/7. If a doctor can't afford a laptop, maybe the extremely rich CMA can donate them to those doctors instead of spending money to lie to voters over patient safety issues they don't like. This is simple stuff, guys. Stop talking about the burdens to doctors. If it's a burden to a doctor, he shouldn't be a doctor. Patient safety comes first. Stop it, Richard.
Thank you for your public comment. Up next here we have Alicia Sanchez, let me open your line.
Can you hear me?
Yes, there you go, Alicia.
Okay,
Go ahead.
great. Thank you. Alicia Sanchez with the California Medical Association. I want to thank the board for recognizing the comments that we made previously and addressing some of the implementation considerations, which, as have been discussed today, can pose some tricky situations. But I do think that the language that's being proposed helps balance the need for consumer information with the considerations of a busy practice management setting. So thank you for the consideration and for the amendments to the previously proposed regulations.
Thank you for your public comment. Up next, we have Virginia.
Seen these messages in my doctor's offices, and I've never used them because I know that the medical board would do nothing about what happened to me. So we belabor all this about this posting, and then 99% of the cases, nothing happens. So we need like a little warning. By the way, even if you do submit this to the medical board, the high chance of nothing will happen would be the warning. And then you also have false records that doesn't help anything being done. So if you post these, we actually need to have action and get something done when the patients complain of medical errors instead of this 99% of them, nothing gets done. And again, I go after the CMA. Thank you.
Thank you for your public comment. Up next here, we have Marion Hollingsworth. Marion, let me send you that invite.
Okay, can you hear me?
You can. Please go ahead.
Okay, thank you. Hello, this is Marion Hollingsworth. Just a quick comment and question. Does the medical board enforce the order to post this notice to consumers? I have seen many offices that either don't have them on the wall, nor do they offer a paper to sign for acknowledgement. I've even seen a picture, I even have a picture on my phone of a framed notice hidden behind a potted plant on the reception desk. And because of my late husband's illness, I have been in a number of doctor offices over the last few years, and I look every time for this notice. I have never seen a discipline listed on the email alert regarding a doctor who failed to post this notice. So why all the fuss over how it's posted, and can anyone respond to this? Do you actually discipline doctors, maybe for unprofessional conduct, if they don't post these? Thank you.
Thank you for your public comment. Up next here, we have Christina Hildebrand. Christina, you should be receiving that prompt.
Hi, Christina Hildebrand. Can you hear me?
We can.
Great. Christina Hildebrand from A Voice for Choice Advocacy. We educate and advocate for informed choice and transparency. I was surprised to hear that the medical board, and I never really noticed it because I never looked at the medical board page for a different number of languages, but I'm actually very surprised that the medical board doesn't have that. There are apps that are incredibly easy to incorporate that you just click on and it asks you what language you want, and you kind of have it, Google translated in, I don't know, 50 different languages. I would ask the medical board apply something like that so that it is accessible for all people in all languages. Thank you. It's not hard.
Thank you for your public comment. At this time, I don't see additional requests in queue.
All right, thank you. We'll bring it back to the board if there are no further comments or questions. Ms. Moriarty, you could please call the roll.
Dr. Gonadev?
Yes.
Mr. Brooks?
Aye.
Dr. Hawkins?
Yes.
Dr. Hilzer?
Yes.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe?
Yes.
Dr. Sy?
Yes.
Mr. Watkins?
Yes.
Ms. Lawson?
Yes. All right, that motion carries. Thank you, Ms. Webb. All right, moving on to our next agenda item, which is item 15, update, discussion, and possible action on the proposed agenda for the Midwifery Advisory Council meeting. I believe Ms. Holzer is joining us.
And I'm here. Can you hear me?
We sure can.
Perfect. For once.
got the technology right. I'm Diane Holzer, the outgoing chair of the Midwifery Advisory Council, and this will be my last time presenting to you all. So our requested action is to approve the following agenda items for the next MAC meeting. The approval of the minutes from the March 3rd, 2022 MAC meeting, the report from the MAC chair, establishing goals for the MAC, a report from the task force and possible action regarding Medi-Cal-related issues, an update on proposed regulatory language for the Licensed Midwifery Annual Report, the LMAR, an update on midwifery-related legislation, an update on the midwifery program, discussion and possible action on the LMAR reminder letter and worksheet, discussion and possible action on midwifery schools and the information on the board's website, selection and appointment of a new MAC chair, and selection of 2 new MAC members, 1 licensed midwife and 1 licensed physician. Background being that the last meeting was held on March 3rd, 2022, and at this meeting the following actions were taken or we got the following information. We approved meeting minutes from the December 9th, 2021 meeting. We received an update from the chair. We received an update from the task force on Medi-Cal-related issues. We received an update on the proposed regulatory language for the LMAR, and an update on midwifery legislation and the midwifery program. We discussed additional language to be added to the LMAR reminder letter and creation of an LMAR worksheet. We discussed adding information to the board's website on how to become an approved midwifery school. That's the possible suspension of further MAC meetings. And we voted to recommend to the board 1 public member for the vacant position on the MAC.
Thank you very much, Ms. Holzer. Is there a motion to approve the proposed agenda for the council?
So moved.
Thank you, Dr. Holzer.
Second.
Thank you, Dr. Hawkins. Any further comments, questions from the board? All right, let's move to public comment, please. Sean, I don't see any here in the hearing room. Move to the WebEx.
Anyone like to make public comment on agenda item 15? Please use the hand raising feature or type something in the Q&A box and we'll get you called on. Everyone, a few seconds here to queue up. This time I'm not seeing any requests.
All right, we'll bring it back to the board. And if there's no further comment or discussion, Ms. Moriarty, if you could please call the roll.
Mr. Watkins? Aye. Dr. Tsai?
Yes.
Dr. Thorpe?
Yes.
Mr. Rue?
Yes.
Ms. Lubiano?
Yes.
Dr. Hilzer?
Yes.
Mr. Hawkins? Dr. Gonadev?
Yes.
Aye.
Mr. Brooks?
Aye.
Ms. Lawson?
Yes. All right, thank you. That motion passes, and the proposed agenda is approved. Moving on to the next agenda item, item 16, discussion and possible action on recommended appointment of Barbara Woodley to public member position on the Midwifery Advisory Council. And Ms. Holzer, you may continue again.
Right. As you said, the action requested is to determine if you want to approve the Midwifery Advisory Council's recommendation to support Barbara Woodley as a public member effective June 30th, 2022 for a 3-year term that will expire June 30th of 2025. The background being that the Business and Professions Code, Section 2509, authorizes the board to create a MAC and appoint licensed midwives, 3 members of the public, 1 of which is a physician. The MAC is an advisory council that represents the midwifery community and the organizations, associations that represent licensed midwives. The MAC meetings are held in public to discuss topics of importance related to the practice of midwifery in order to make recommendations and provide advice to the board. The board received 2 applications for the public member position. The MAC voted at the March 3rd, 2022 meeting to recommend to the board the appointment of Barbara Woodley to the public member position. And staff is recommending that the board approve the MAC's recommendation to appoint Barbara Woodley.
Thank you, Ms. Holzer. May I have a motion to approve the appointment of Ms. Woodley to the MAC?
So moved. Hawkins.
Dr. Hawkins?
Second.
Thank you, Dr. Helzer. Are there any questions or comments from members? All right, seeing none, are there any commenters on the line, Sean?
I'd like to make a comment for agenda item 16. Please raise your hand or type anything in the QA window and we'll get you called on. Give everyone a few seconds here to queue up. This time I'm not seeing any requests.
Great. We'll bring it back to the board. If there are no further comments or questions, Ms. Moriarty, if you could please perform the roll call vote.
Mr. Brooks?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Yes.
Dr. Hilzer?
Yes.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe?
Yes.
Dr. Sy?
Yes.
Mr. Watkins?
Aye.
Ms. Lawson?
Aye. The motion passes to approve Ms. Woodley's appointment to the Midwifery Advisory Council. And Ms. Holzer, before you depart from our meeting, I just wanted to thank you for your service to the MAC all these years. I understand this is your last meeting at which you'll be presenting to us, so our best wishes to you in all your future endeavors. And again, thank you very much for your service over all these years. We really appreciate it.
Thank you very much.
Thank you. All right, we are moving on. Moving right along. Next item, item 17, future agenda items. Do we have any future agenda items from members? We'll start at the very end. Dr. Thorpe.
I would just like to request again regarding the opioid task force and its recommendations for a change, that we engage the pharmacy community, specifically the Board of Pharmacy. And I don't know how that can be done best, but I would ask the president to sort of coordinate that, and I'd be happy to help in whatever way I can. But I also would just like to make sure that I think the recommendations that were given earlier by the public about making sure that the pharmacy is engaged in this, the Board of Pharmacy, and that there's a coordinated effort to try to move the bar is going to be required. And I would like to see that happen as soon as we can get our, we're in the process, of course, but to help coordinate that, I'd appreciate that.
Excellent, thank you. Ms. Lubiano?
Thank you. I wanted to make a request on a presentation on LGBTQIA health. Just any disparities, or for us to learn more.
Excellent, thank you. Mr. Watkins, I saw your hand.
Oh, yeah, I would like to see maybe a presentation. I've just recently been reading about trauma-informed training. I know it's been requested previously. I thought it was interesting, and there were some interesting issues there. Trauma-informed training.
Got it, thank you. I'll look over to my left. Any requests for agenda items? Just one from me. I'd love for us to think about, and it might be a presentation, it might be just some offline coordination amongst agencies in California, but a conversation on this issue of medical misinformation and disinformation that involves agencies like CDPH, like the Department of Justice, us, of course, likely other agencies I'm not going to think of right now, but I'd love to convene a conversation about the best ways for us to address this really important issue going forward. I don't think it's a single agency issue, and I think if we're talking to each other, we're going to have a higher likelihood of having some better outcomes. So, again, I'm happy to work on that, offline with staff before our August meeting, but even having a panel discussion of experts from various agencies on what our tools are, what the approaches are, I think would be really helpful and informative, not just for us, but for members of the public, and also for our licensees who are, faced with having to deal with and confront misinformation on a daily basis. So, all right. So if there are no further agenda item requests from the board, we'll move to the public. And Sean, let's just open up the WebEx. I don't see anyone here in the hearing room.
Sure. First up here, we have Dr. Hannah Ree.
Yes, thank you. We may have already had a speaker discuss, disability and physicians with disabilities, but it may be a topic to revisit. So as we know, there was a case over a decade ago regarding a physician who sued the medical board regarding physician disability, which resulted in the medical board accepting or reviewing physicians with disabilities and whether they would be able to accommodate them and that sort of thing. So even after that was established by the board, the medical board continues to discriminate against physicians with disabilities, those with mental health issues. And so the reason why that would be relevant for the medical board is because you may or may not be aware of this, but that members of the medical board can be held personally responsible. They are not immune to being sued for ADA discrimination because the state of California receives disability federal funding. And because they received that funding, they abrogated their right to immunity. So that might be something to revisit because diagnosing a physician with a mental illness and then revoking them or reprimanding them and then publicly detailing their medical information online is it's a violation of civil rights. So that seems to be ongoing with the medical board, and it may be a topic which needs to be reviewed. And I say this because currently Ms.
30 seconds
Lawson
for me.
is a defendant in a federal civil rights lawsuit for which she is not immune. And so it might be something to revisit. Thank you.
Thank you for your public comment. Up next, we have Eric Anders.
Well, I don't know why I bother, because it seems like you guys almost never, pretty close to never, add anything to the agenda that the public asks for. But for the newer members of the board, I have been asking for an agenda item, look at Carrie's face, for probably 4 or 5 years now. And for some reason, the board refuses to ever talk about it. And the only reason I can think about why they would refuse to talk about it or have a presentation on it is because they know they're going to be wrong and I'm going to be right. I have documented now for ever since my sister was killed and this board closed her complaint without investigation. I have been doing public record requests through the California Public Record Act request. And I've done, well, how many do you think, Carrie? Hundreds? Probably hundreds. And a good portion of those are turned down by Carrie Webb without reason. She always claims that there's these exemptions in the law, but the exemptions aren't mandatory. The board does not have to turn anything down. They can provide anything they want. And I've asked for this topic to be discussed on an agenda item dozens and dozens of times, and it never appears on the agenda. And I can't help but wonder why you as board members aren't curious as to why it isn't ever put on the agenda. Why does Carrie Webb not want this put on the agenda? Why does the board not want this talked about? Why does this board not want a presentation on why the California Medical Board denies California Public Record Act requests? We have documentation on a 10 News report from San Diego that the medical board tried to charge them $6,590 to reply to a California Public Record Act request. The intent of the Public Record Act request is to give free information so that the public can get information on governmental agencies that they could be trying to hide from us. And the board is using their loopholes to try and charge people to dissuade them from getting this public information. And they know that there's things that we're going to find out if we get these Public Record Act requests fulfilled, So they jump through their little hoops and they say, oh no, it's exempt, it's exempt, it's exempt. And then they don't send them.
30 seconds.
Once again, I would like the board to address the Public Record Act law and why Carrie Webb is allowed to deny them and grossly charge the public for information that they are due free. Thank you.
Thank you for your public comment. Up next, we have Virginia. Virginia, you should be getting that prompt on your end.
Hello again. My request is dissemination of medical research so we can update standards of care. Trauma-informed care, which at least 4 or 5 of the members have also mentioned as an important topic. Agenda item, how the medical board can prevent medical errors from happening in the first place. Patient safety member on the board and bringing back the patient advocate meetings, and also one on liposuction and the harms of liposuctions and what we can do about it. Thank you. Oh, and Dr. Thorpe, I hope you feel better soon. Thank you.
Thank you for your public comment. Up next here we have Christina Hildebrand. Christina, you should be receiving that prompt.
Hi, Christina Hildebrand. Can you hear me?
We can. Please go ahead.
Great. Christina Hildebrand from A Voice for Choice Advocacy. I would second Eric Andrus's request for the extortionate amounts that are charged for the medical board requests, Public Records Act requests. There is not one single other. We do a lot of Public Record Act requests at A Voice for Choice Advocacy, and there is not one single other entity that charges anywhere close to what the medical board charges for Record Act requests. I actually go to places like CDPH and ask for communication. If I know the medical board has had communication with a different department, I'll go to the different department and ask them, because they'll give it to me for free and the medical board will charge me. So I second that one. I have 3 others. One of them, I also second the last caller on the patient advocacy meetings. You know, we were given 1, maybe 2 of those, and then they were shut down because it didn't sound like you wanted to hear from the patient advocacy groups, because we were being told what we wanted to talk about. So let's have open meetings where we get to set, the patient advocates get to set the topics. I would like to see, and I've asked this many, many times on the agenda, I would like to see one item on the agenda every single meeting that is dedicated to patient advocates giving presentations. So the patient advocates, you choose, patient advocates can put in for a request that they want to give a presentation, and then you choose one of those groups to give that presentation to the board. So that we're actually being heard on the topics we are trying to tell you about in every single public comment on these darn meetings. So give us a placeholder in the agenda. And then the last one is, I am just so thankful to the conversation about standard of care in these 2 days. I just want to reiterate that, and I'm saying this from my heart. If you listen back to the medical board meetings over the years, this is what I have been, and our organization has been just trying to get across to you. And the conversation on AB 2098, I'm very disappointed that the conversation did not reflect the votes that should have happened, but at least the conversation happened, and we had people like Dr. Ganade, making comments that standard of care is fluid and that we should be looking to innovation and outside of the box and all of these things. So I really ask, the meeting you had, or the agenda item you had in 2020 by Gloria Castro, didn't address that. It addressed what is standard of care, and that's the standard of care that is in the box. We need to be thinking outside of the box here in California, and I just ask you to have a agenda item on standard of care and the fluidity of it, and thinking innovation and outside the box and what that does to standard of care. Thank you.
Thank you for your public comment. Next up here we have Marion Hollingsworth. Marion, I'm going to send you that request.
Okay, can you hear me?
We can. Please go ahead.
Hello, this is Marion Hollingsworth. I'll be brief. I would like an agenda item on the disciplinary letters that Executive Director Prosifka was going to be sending out to doctors for minor violations. I would like to know how many of these letters have been sent out and the type of violations they were used for. I know these are confidential, but some indication of how this new letter is being used would be helpful. Thank you.
Thank you for your public comment. Up next, we have Michelle Montserrat Ramos. Michelle, you should be receiving that prompt. Michelle, I don't see you clicking that prompt. If you're there, you should. I don't believe Michelle is available. That was the last request in queue, and I'm not getting any more messages through the Q&A or seeing her clicking that prompt. Let me try one more time.
Okay, let's try one more time to reach Michelle. And if not, if she can hear us, I would just ask her to send me an email with her specific request. For some reason,
There, she got it.
Sounds good.
Good afternoon. Thank you. I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Can you please place the complaint tracking system as its own agenda item so we know it's going to be addressed? Also, place the complaint unit as a separate agenda item so we know that it's going to be up for discussion, and would appreciate that we receive some communication with board staff in between meetings since we primarily push for both of these projects. If you could place the update of the consumer complaint information video on the agenda and update on the legislative oversight hearing of the medical board and the reports that the Senate chair asked for. An agenda item to discuss bringing back the committees to the quarterly board meeting, including the communications committee that Dr. Hawkins was supposed to chair. It was scheduled and canceled and was never rescheduled. Thank you.
Thank you for your public comment. This time, there are no additional requests in queue.
All right, thanks. We'll bring it back to the board. Are there any additional agenda items that popped into your mind? Dr. Thorpe?
Madam Chair, I would just like to recognize Dr. Kananadev since this is his last meeting. You know, I don't know how we will be able to replace his depth of understanding about academic medicine, about the practice of medicine, about the details of surgical practice. He has been an invaluable member of the board, and it's going to be a real challenge to replace him, not to mention his good nature and his friendship. So, Deb, we just want to tell you thank you from the bottom of our hearts for your service, and we recognize the contributions that you've made here for the last 12 years. And we just can't thank you enough for your service.
Yeah, thank you, Dr. Thorpe. And I was going to make mention of that. I think you've served on the board since 2011. You've certainly been here the entire time I have been here. Just a terrific source of wisdom, good dry wit and humor too. And you've also been just incredibly supportive to me in my role as board president as well, which I really appreciate. So thank you for your service. We are definitely going to miss you on this board. Others?
Don't want to belabor it. Thanks, Tess.
Drew?
Thank you, Madam Chair, and I'm glad that my first meeting live and your last meeting is today, where I get to actually see you in person. I really appreciate your analysis during the board meetings of your thoughts, especially being on the board for so long, Dr. Kanadev. So I really appreciated what you had to say, and I'm glad we got to meet in person. And it's really unfortunate that you're getting off, but I know you'll still be very accessible to us, which we very much appreciate. And I don't know if you want to be accessible to us, actually, but even though you're off the board doesn't mean that you're gone. So, but thank you for your service.
Thank you. Actually, it's just a little less than 11 years, not 12. I don't want to get this even, can't say worse than what it is, but So I'm actually, it's usually you don't get that feeling till you're coming towards an end where you feel that, well, thank God it's done. I did my God's work. What was, this is a volunteer work we all do. I mean, somebody mentioned that you guys get paid $100 a day. I mentioned that, hey, I'm a vascular surgeon. I can earn that in 10 minutes. So that's not the reason why we're here. My goal was always the betterment of profession. That means that truly taking the bad doctors out, helping doctors if they make simple mistakes, and protecting the consumers. They all are in the same boat. They're not one different from the other. This is where sometimes understanding it's difficult. And like I was telling TJ and I agree on a lot of disciplinary actions in panel. It's, as I mentioned, even though he doesn't have the knowledge of medicine, and I do as a triple boarded person, I do have a lot of knowledge of medicine, but plus I've been training and teaching students and residents, but it just takes common sense to just see where the problems are. So this board is great. I think we went through some tough time last year, but you guys will be fine. You got new blood coming in. And I would be fine because I got, as you know, I do 10,000 things in life. So, and that's where there is no retirement in mind for me, because between my group, my hospital, and local political activities, so we got a lot of stuff. Thank you, though.
Well, thank you, Dr. Gnanadev. And before we adjourn the meeting, I also want to take the opportunity to recognize Dr. Yip, who has served on the board since 2013. This was his last meeting as well. Unfortunately, he was called away following the panel meetings for an emergency back home in Southern California, so he wasn't able to join us for the full board meeting. But we have, of course, appreciated his wisdom, his good nature as well. And he always, I think one of his hallmarks was his really terrific relationship with our staff, who he just held in the highest regard and always really made a point to reach out to and interact with. Dr. Hawkins, you want to?
I just want to say something about Felix. So Felix was chair of enforcement, and he was constantly trying to educate us about how to improve enforcement, try to learn from what we're exposed to in the discussions we had in our various meetings so we could do a better job. Felix was always thinking about making it better.
Yeah. All right, so with that, Dr. Gnanadev, we will miss you. Dr. Yip, if you're watching, we will miss you as well. But this meeting will stand adjourned. The next meeting of the medical board is scheduled for August 19th and 20th. We will be in person again for that meeting, and of course the location will come out on the agenda in advance. So hopefully some of you can join us in person. Thank you all for participating. Thank you to staff for all your hard work in making this happen. We really appreciate it.